with regard to the issue of NGI.
What happened?
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Schuabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Were you able to determine whether or not Dr. Litton actually assigned a diagnosis herself?
It seemed implicit in the report that she concurred with the bipolar diagnosis, although it was not explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that typical in your experience to not assign a diagnosis during such an evaluation?
In an NGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here?
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
I lost you guys.
Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Yes, the greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
Okay. The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Schuabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Litton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Schuabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
Yes, I did.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Litton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed, and jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I'm going to object only because that calls for hearsay. I apologize, but overruled.
I forgot where you were in your answer, but if you're...
another question.
Sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report as part of a competency instrument that she administered to the defendant. Embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known. And the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent even for a patient with legitimate schizophrenia.
And did you note whether or not Dr. Lighton performed any such psychological testing to determine the validity of the symptoms that she was observing from Ms. Schabusiness?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes, in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. Schabusiness when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicative competency.
Can you explain that maybe just in a little more layman's details?
Yes, and so to the extent that the defendant would have presented similarly as she did with Dr. Lighton, for instance, presenting herself as very distracted by hallucinations, unable to supply linear or coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point, that the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
I heard him say a little bit that she faking the funk. I stepped away to the laptop to reset it up on Facebook. I don't know what's up with the connection, bro. Why I did that? I forgot to set the setting not to disconnect when the connection drops. So I should have been able to connect
Doctor,
right back.
you also had an opportunity to review the report of Dr. Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to the issue of NGI.
Now, some of the shortfalls of Dr. Lighton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Lighton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that again would have been in that time period leading up to this offense. And she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. Schuabusiness's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant, and then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related to general diagnoses of a mental health condition, but can you talk briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. And so to the extent that an examiner cannot rule out the sequelae of that voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Amazing.
Cross-examination, Mr. Freilich.
Thank you, Your Honor.
What they got?
Dr.
What they
Seipel,
got?
good afternoon.
Good
Bring the
afternoon.
heat.
You prepared 2 reports concerning Taylor Schabusiness, correct?
Yes.
One in November of 2022 and then one in July of 2023, correct?
Yes.
And you received police reports, correct?
I did not review the police reports.
Okay. Did you review the criminal complaint?
Yes.
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the 2 gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Yet you criticized Dr. Lighton for not doing it, correct?
Yes.
Now, you've been a licensed psychologist since February of 2022, correct?
Yes.
That's when you obtained your license to practice and do evaluations and reports and all of that, correct?
My license enabled me to practice independently, although I performed all of these evaluations under supervision from September 2020 up until that time.
In September of 2020, that's when you were a fellow?
That's when I began my postdoctoral fellowship in forensic psychology.
Okay. When you've had a chance to review Dr. Lighton's curriculum vitae, correct?
Yes.
You've had a chance to review her evaluation from July 3rd of 2023, correct?
Yes.
As far as experience level, she has more experience than you. Is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
And with regards to Dr. Christina Engen, she works in the Wisconsin Forensic Unit as well.
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the 2 of you are aligned as far as opinions in this particular case. Is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the ultimate recommendation is the same, correct?
I guess I'm not sure what you're asking, sir.
That you and her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County Jail records, correct?
Yes.
You reviewed Bell and Health records that I sent, correct?
Yes.
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
Yes.
You reviewed a lot of mental health records, correct?
Yes.
Fair to say that Taylor Denise Schuabusiness does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill, at least in 2021. Is that fair?
According to that court order, it would suggest that, yes.
And then she was on a medication order in order to take psychotropic medications for that same period of time, correct?
Yes, it is my understanding she was court ordered to medication compliance.
A lot of different doctors evaluated and took a look at Ms. Schuabusiness, correct?
With respect to the pendency of this case or more generally?
Just with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins, yes?
Yes.
Dr. Tracy Lucetta,
Yes.
Dr. Diane Lighton,
Yes.
yourself,
Yes.
Dr. Christina Engen,
Yes.
With regards to Ms. Schuabusiness's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristata?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristana, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood-stabilizing properties as well.
That boy, dang, smart though. Like a robot, like an AI system.
And fair to say that through Brown County, through Nicolay, that Ms. Schuabusiness was given a diagnosis of bipolar disorder.
Yes.
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged.
Yes.
She was discharged, after she had her baby.
What was the question, sir?
Do you know? I'm sorry. Do you know if she was discharged after she had her baby?
I do not believe she gave birth during the course of that hospitalization.
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Schuabusiness suffering from paranoia?
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that, in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center where I saw the hallucinations mentioned.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay when she had heavily been abusing methamphetamine recently.
You've been a doctor for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many different kinds.
With all different sorts of problems, correct?
Yes.
And you've dealt with people who have had drug addictions and things of that sort, correct?
Yes.
You've gone to seminars with regards to how substances can affect the brain, correct?
Yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
Okay. And would it be fair to say that substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Brain on drugs. Remember the egg thing? The cooking the egg? Your brain on drugs, bro.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
They used to try to scare everybody with that shit, right? Oh, this is what your brain is like. They got an egg frying in the pan back in the day. Oh my God.
What causes memory impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly, if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
I forgot about that.
Yes, it is.
Can that get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
And can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
People are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. Schuabusiness had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have occasion to, when you met with her, to observe that she had a tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engen or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. Schabusiness identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her in November of 2022 or July of this year?
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
In some of the records, did you note that it indicated her affect was flat when approached?
Yes, there were some indications of a relatively flat or diminished expression in her emotional presentation, yes.
What does that stem from, do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
John.
Also in these progress notes, did you indicate or did you review, excuse me, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that in the Nicolay notes as well, yes.
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time, yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms, a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night, they'd be more pronounced at night than the daytime?
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
Pivot.
There were, it's true, right, that there were discussions about her getting this Aristada injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Ms. Schuabusiness would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review, and you have a good memory. But it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent treatment records.
Man.
And Ms. Schuabusiness was given, apparently at Nicolay, from what you reviewed in these notes, what are her coping skills and what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
Okay. With regards to Dr. Lighton, she says that she believes that my client, Ms. Schuabusiness, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Schuabusiness's ability to know right from wrong at the time of the offense, correct?
I would say it was relatively tersely worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed opinion compared to Dr. Lighton, correct?
Again, I did not opine on the NGI issue.
Okay. All right. Thank you. Nothing further.
Be direct.
Just briefly, I think you were asked a great deal again about the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. Do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. Schabusiness have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged mixed conduct?
Correct.
I would say that from what I saw, Dr. Lighton was the only one that, and again, it wasn't really directly discussed, so at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022, is that correct?
I did not see any indication of her being actively involved in psychiatric treatment, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether or not an NGI offense or an NGI defense is appropriate for Ms. Schabusiness in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, Your Honor. Thank you, Dr.
Thank you,
Slade.
Doctor. You can step down. State's next witness.
State calls Christina Engen.
Another one? Oh, shit. Man, we're really going to be here 10 hours today, huh? Really running long today. If I were to opine my thoughts on Taylor, she's a duplicitous person and at times malingers, and her attorney is very pedantic. Yes. Waiting for that. Just throw them all together. I like the opine thing too. I can't see myself trying to use that shit, but I'm gonna try. Opine. I'm going to opine my thoughts on this situation. I did not opine on that. Not that in particular, no.
Doctor, if you just step
Doctor was
forward
something
here,
else, huh?
Then before you have a seat, if you could turn and face her and raise your right hand, she'll place you under oath.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter, now before the court, so help you God. Yes. Please have a seat and state your name for the record.
Christina Engen, CHRISTINAENGEN.
Mr. Saunders, the witness is yours.
All right, Doctor, how are you employed?
As a psychologist with behavioral consultants,
And how long have you been employed with behavioral consultants?
12 years.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
All right. And I guess what do you do as a psychologist with behavioral consultants?
I conduct almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is, forensic evaluations? What does that mean?
The court principals will approach a psychologist with a psycho-legal question. So a psychological question that applies to the legal situation, and our job is to help answer that and to provide information to the trier of fact, the judge or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess, what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal
Oh,
responsibility.
she winking. What?
And you have performed those evaluations in the past?
Yes.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And Doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right. Showing that's been marked Exhibit 12. Do you recognize that?
Yes.
And what is that?
It is my curriculum vitae.
And does that appear to be up to date?
Yes,
All right. That's a document that you prepared?
it is.
I'd move 12. Any objection?
No objection.
12 will be received.
Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology. Applicants can specialize in several different areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
With the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. What are some of those?
I've provided guest lectures for Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Correction psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor Schabusiness?
Yes.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
And is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Doctor, I'm showing you Exhibit 13. Do you recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
And does that contain your, I guess, factual findings and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
Any objection?
Subject to cross, Your Honor, no objection.
13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Yes, the evaluation consists of a clinical interview, so a meeting with Ms. Schabusiness. I also conducted a full discovery review, so review of all of the police reports, videos, documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
Okay. So I want to first start with the clinical interview that you mentioned conducting. What date was the date that you met with Ms. Schuabusiness?
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
And October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes.
Okay. And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
Correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Schuabusiness from February 23rd of 2022?
Yes,
Was that a rather lengthy interview?
it was.
Did you review the entirety of it?
To the best of my recollection, I believe that I reviewed the vast majority of it. If I would say the majority of it.
All right. Were there a lot of dead parts in the middle of it?
There were, but I thought it was important to review that video footage to listen for comments that Ms. Schabusiness would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case?
Yes.
The medical records that you reviewed, you mentioned there were prior competency evaluations, but also Brown County Health Services records, is that right?
Correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right, and when was that?
That spanned March of 2021 to April 2021.
All right. And you then indicated you also conducted a, personality test, or what was the fourth collateral source you reviewed?
I can administered an objective personality test. It's called the Minnesota Multiphasic Personality Inventory, 3rd edition. The acronym is MMPI-3.
Okay.
I guess the camera's frozen.
So I want to then go through your report, if that's okay, Doctor. Beginning on page 2. So one of the things you start with is called relevant history. Do you see that section of the report?
Yes.
And I guess why is it important to review the history as part of your NGI evaluation?
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Schuabusiness's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue, so can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Schuabusiness's mental health history as well?
Yes.
As we talked about. As well, did you review her, during the course of your clinical interview with Ms. Schuabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting, as you do, the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
Okay. As part of the clinical interview with Ms. Schuabusiness, do you get a narrative from her about the alleged offense?
To the extent that I was able, I did. Ms. Schabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she did not. She reported she did not regain memory until after her arrest.
Okay. With respect to Ms. Schabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety, and I understand that she struggled during this time period, was feeling what sounded like to me some alienation in the workplace. Not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those, you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those were all kind of leading up to the date of the offense?
Correct.
With respect to February 21st, 2022 specifically, did she have a narrative about sort of the timeline of events leading up to the offense?
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she was staying in. I believe they were smoking marijuana. She expressed an interest in finding methamphetamine, and so she said that she went on a, quote, meth hunt, end quote.
Did she indicate whether she had ingested methamphetamine leading up to the homicide?
Yes, she told me that she took 52 hits of methamphetamine.
And did she also refer to that amount as, quote, a lot?
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes.
And then you indicated around the time of the alleged offense, she reported having no memory of that time.
Correct.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement?
Yes.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the October interview.
You also indicated during the interview with Ms. Schuabusiness you performed some psychological testing, is that right?
Yes.
What testing did you administer?
It was the MMPI-3.
What is the MMPI-3?
It's a very well-established psychological instrument dating back to the 1940s, very well researched and respected. So this test can provide indication of different types of psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
So the validity indices, I think I said that right, that you mentioned, I guess What does that mean?
What that means is that built into the test are several items that, when they're all combined at the end, they'll indicate if a person is answering questions in a forthright manner, if they're minimizing their symptoms, or potentially if they're exaggerating their symptoms.
So is this test like a true-false questions, or how does this test administered?
Correct. It's a true-false instrument.
And I guess what were some of your findings with respect to Ms. Schuabusiness's performance on the MMPI test?
Well, first, let me be clear that the test does not say anything about Ms. Schabusiness's functioning. In February of 2022, it only provides information about her functioning at the time of the test. So what was relevant from that was that there was indication of symptom exaggeration. She responded to items, she endorsed a number of symptoms that genuine individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. And that was a good point. So this testing is sort of in the moment as you're meeting with Ms. Schuabusiness, is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Ms. Schuabusiness's self-report could not be taken at face value.
Okay. And I think you state that anything that's not objectively observed should be closely scrutinized. Is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
And one of the phrases you used was endorsed symptoms. What does that mean?
For example, I'm just making this test example up, but I feel depressed. A true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Ms. Schuabusiness, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Ms. Schuabusiness was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
And in your report, you outlined, I guess, 3 mental health conditions. Is that right?
Correct.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Schuabusiness's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Schuabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this indicated to me the presence of psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So, mental health conditions, in your opinion, are different from mental diseases or defect?
Correct.
And the three diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding, based on the case law, that the defendant would be subsequently responsible for all alterations of thinking, judgment, behavior related to that intoxication.
I guess, were you aware of any information in the materials you reviewed that Ms. Schabusiness's methamphetamine use was anything but voluntary?
No.
And that obviously she reported a history of using methamphetamine to you?
Yes.
So I guess, were you of the opinion that she was not naive to its effect?
Correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess, in your experience and in your education training, are you aware of some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
Excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms, so misperceptions of reality, and paranoia.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes.
And did you consider, I guess, the applicability or the appropriateness of a bipolar I disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar I disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar
I can't unhear it now,
indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar I disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And
Need to get a counter.
are you aware of any of those symptoms absent in the context of methamphetamine use?
I am not aware of a time ever that Ms. Schabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar I diagnosis was applied to Ms. Schabusiness in April of 2021.
Yes.
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
Yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Schabusiness.
Objection leading.
Just clarifying the testimony. I'm just clarifying the testimony, Your Honor.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Schabusiness with?
Yes, also offered at Nicolay or Nicolette, I'm not sure the pronunciation. There was a diagnosis of, I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe that, I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Okay. Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
Okay. And what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found in my report, I outlined various different factors, but focusing on the two issues, one's ability to conform their behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement expressing apologies to the victim's sister, indication that she was trying to conceal the body was dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find the self-reported amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was not, that she was reporting non-credible memory impairment.
Are we done with this already? What? God almighty. It is a bad habit. I do that. I probably do it more than I realize. But she's like overdoing it. I think it's that need to fill the empty space or try to, in between thoughts. People, I struggle with that too sometimes where, especially with streaming and online, I used to have this mentality that you kind of have to constantly, if you're not saying something at the moment, you have to fill it up. And it's okay to be a little silent, have some pauses. But that's excessive. And that's a really hard habit to get
You have
past.
just a few more questions, Doctor. Your report was done in November of 2020.
Being careful when I talk now.
Yes.
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
Yes.
And who authored those reports?
Diane Litton.
Okay. And in your review of Dr. Litton's report, did any of her findings or conclusions alter your opinion from November of 2022?
No,
I guess the same opinions you're testifying here to today?
it did not alter my opinion.
Okay. And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further on.
The weird thing too is she was saying it in the middle of talking.
Would we be able to take a break right now or not?
He was looking for a break, this guy too.
Okay. Ladies and gentlemen, we'll take a 10-minute break, and we'll resume. All rise for the jury.
It's a really bad habit. That's something I've always wanted to personally work on myself. I don't think I do it a lot, but when I'm editing videos, I do hear it, and I'll sometimes take it out. You can edit it, take it out, like the or whatever she's doing. But she's very, very, very excessive. Holy crap!
And Doctor, you can step down.
That's pretty bad. I've heard it that bad before.
We'll be in recess then for 10 minutes. I'd like the attorneys to return. Obviously, 10 minutes is a little bit before 3. I'd like you here a little bit before 3 so I can speak to you a little bit about these instructions, okay? So we're in recess.
I really think the judge is trying to get it done today. The judge is not playing. We've had some days. I feel like we've done almost 10 hours. He's trying to get this shit done. I'm kind of hoping this is done today. We should at least reach where the jury is deliberating. And I think that no way. I'm going to go with you guys from yesterday. I don't think more than an hour. I think an hour, even though they're bringing out these other witnesses, and the defense didn't really do much. They brought out, I was going to say one witness, but they brought out two, actually, the father and then this doctor. I feel like there's something I wanted to show you. Oh, there is something to kind of talk about. Oh boy, fuck. Nah, I'm so like conscious of that shit now. It's so weird. Let's show these ads, right? Because the drug ads, right? Flat anti-pot ad. I don't know if they're gonna. Let me do this a little smaller.
So, Sarah, what's going on here? Sarah?
She won't answer you. Or she can't.
Why not?
This is the way it's been since she started smoking pot. She's all lazy and boring and... You know, we used to have so much fun together.
And now?
This is what we do.
What kind of side effects about smoking marijuana were discussed in the video? If you're concerned about a friend or family member, what should you do? Is it illegal to smoke marijuana? Okay, wait. Oh, that's it. That's what I felt like when I did dabs. The one time I'll never do that shit again. Like the crack of weed. Never do that again. But I felt like that. Kind of like in the couch.
Sarah.
She won't answer you. Or she can't.
Why not?
This is the way it's been since she started smoking pot. She's all lazy and boring and... You know, we used to have so much fun together.
And now?
This is what we do.
Yeah, that's from 2013. Oh, they actually have 480 though. I'm surprised they got that quality. There's another one too. Someone in the chat was telling me earlier. I think it was is it GZA? Get him in the chat. I think it's GZA. He said to look up this video. Oh, there's well, I may not do that one, but there is the crack one. I don't know what this is about. Is this right? Okay. Don't let your kids go roller skating because skating rink is occupied by. What is this? Is this real? Is this the one? You tell me this is right.
Hey kid, would you like some drugs? The first one is free.
Want to check out my van? I got some candy.
Hey, kid, you want to join our gang and spray paint under a bridge?
No, bug off, man. I'm going roller skating.
Oh shit! So what is it? Don't do crack. Go roller skating. All right.
I want to be addicted to roller skating, not crack. Because we roller skate today, we will go to college tomorrow. Prison is full of people that has never roller skated.
I'm Brad Armstrong, owner of Roller Kingdom in Reno, Nevada, keeping your kids off the streets since 1999.
I say no to drugs. I say no to gangs.
I say no to unplanned pregnancy.
I say no to meth. I say no to reefer. I say yes to roller skating.
Man, this roller kingdom is really putting us out of business.
You said it, man. This deal sucks.
But you know what? Maybe we should give up this life of crime and start roller skating.
Wow. Amazing. Wow. Okay. I guess that's kind of fitting the drug commercials. The other thing that we could talk about real quick too, the judge don't play. Boy, it's 10 minutes, but they said come back before that for the attorneys. The judge don't play. Let's just cover this real quick. This should be quick. That shit was really funny. A little update. Let's check out this mini update on our hoax friend, Carly. People in the chat were telling me Diggs and other people hoax. Alabama police seeking 2 misdemeanor charges against Carly Russell. So I don't even know if she'll even do time. Charges that could be filed in Alabama against Carly Russell carry a maximum 1-year prison sentence. I really don't think she'll even serve time. Police are seeking 2 charges against Carly Russell, the Alabama woman who went missing and returned home 2 days later. We know all this stuff. We know she dialed 911. We know all the time stuff. Tolbert told Fox News Digital that police are seeking to charge Russell with false reporting to law enforcement authorities and falsely reporting an incident, both of which are misdemeanors and carry a maximum punishment of 1 year in jail. So I guess that's all they can get on her. I guess the job is not going to charge her with anything. The Hoover Police Department declined to comment when reached for comment. Okay. That's it. It's like 10 seconds. All right. That's interesting. I guess a mini update. I don't know. Will she really do time with those kind of charges, misdemeanor? Probably not. Maybe it's the whole thing of her never saying that she was kidnapped. She did a plot but never said she was. I wonder if that's has to do with anything like that. Hoax says probably probation, community service. They're probably misdemeanor, especially if she doesn't have any other offenses, right? She don't got to do any kind of time, I don't think. She got, like, I think that high profile attorney. Oh, hoax, not hoax. Cinema did post something kind of funny. The Twitter. Let's see. World of Twitter. Or X. I gotta say X now, I guess. X. He over here said, I finally found out where Carly Russell was for the 49 hours. They really have a Cheez-It themed hotel room. Cheez-It, these Cheez-It themed hotel rooms are real. Check them out. Wow. That's it. Is it real for real or not for real? It's Florida too? Oh, Lord. Man, those drug commercials from back in the day, huh? I'm looking for this to be over today. Hopefully over today. But then we can cover whatever else. Maybe take a little mini break, 1 or 2 days. I don't know. Who knows? Everything's up in the air because things just change day by day. Because it's really nothing for me to jump on for an hour or two to cover a story. Well, wait until the next trial. So the whole thing too with the next trial thing, that Mallory Beach thing is not happening because Cheeks sent me an article the other day. They settled, I guess, out of court. Let me see for how much. That's not going to happen. I don't know if the witch doctor thing will happen in August. I'll keep an eye on that. Let me see. Settlement. How much? Okay, $15 million. South Carolina judge has approved a $15 million settlement between Mallory Beach's family and Greg Parker, the owner of a convenience store that sold an underage Paul Murdoch alcohol.
Okay, be seated.
I don't know what happened to me, Carly. I've been kind of figuring out why I don't have the trial stamina. I don't know what's going on. A friend of mine said because I stopped doing it. I don't know if it's because we've done more this year than I've done the other years. Wait, when was Murdoch? Was Murdoch this year? How many trials did we do this year? I feel like Murdoch was this. Was it this year? I don't know. Was it last year? I'm not sure why I'm feeling how I feel with this trial. No, I haven't heard nothing really with Brian Kohlberger. I mean, I'm waiting for that. Brian Kohlberger, the suitcase lady, Sarah Boone. I heard that got pushed back again. Yeah, this trial. Oh, hoaxes because it's boring. The thing is, too, with this, it's not much of a mystery. As there's not like something up in the air, like is she gonna be found guilty or not? It's so like apparent and so just. There's not like a mystery to it. We know what she did, a horrible act.
Before we bring the jury out, just briefly, I've had distributed to you a set of instructions and a proposed instructions and a proposed set of outline as to how they should be given. There's certainly other instructions that could be given, that were given to the jury the first time regarding objections of counsel, improper questions, things of that nature. Although they've gotten all those instructions already, I'm not sure the need to do that. But I'm going to start with the state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out? Alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we could do the closings. When I look
Even
at
better, knock it out.
605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? But then in question 2, it says, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect, because it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is, you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions, and I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page of 605B, the comment about the possibility of using the phrasing mental disease and defect, and then it cited the case. I don't think that's appropriate to use "and" in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one, but it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to "and." Nonetheless, I wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to "as a result of the mental disease or mental defect." Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an "or," Mr. Freilich, versus an "and"?
I've always thought that it was an "or," Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to "and," and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as "or." You're not asking for anything else. You don't have any objection to "or," do you, Mr. Saunders?
No.
Okay. Very good. I'll add that one word in, and then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay.
Yeah, I thought
anything
that
else
was
before
it.
the jury comes in, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right.
This is Chrissy. Thank you for the membership. Thank you for gifting that. I thought that was the conference. Let's see how many more. What are that? Well, they have the same doctor still in this then? I think they're almost done. I think the jury instructions should be pretty quick. Doesn't seem like there's much of anything for them to fight over or disagree on or change. And the closing statements, hopefully that's not too long either. I mean, the previous closing statements weren't long, so I don't think these will be long as well. I don't see this woman having any chance in hell being found not guilty by reason of insanity, or however they call it over there, mental, I forgot the word they say, right? Mental, I don't know, defect or something.
All right. Then we're back on the record, and we're up for cross-examination. Mr. Freilich, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much. Dr. Engen, good afternoon.
Hello.
Hi. So you work for behavioral consultants, is that correct?
Yes.
That's in Milwaukee?
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
Okay. And with regards to this case, you did not do a competency evaluation, you did an NGI evaluation?
Correct.
You met with Taylor Schuabusiness, correct?
Yes,
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail on October 12th and October 21st of 2022?
Yes.
Have you met with her since?
No.
So it's been, is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first time that you tried to see her, there was some sort of a security issue going on and you were not allowed to see her, is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years, is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true-false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
So I provided, an example that I made up, but there's various statements, and the respondent is asked to respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
Okay. How long does it take to get through the test?
In the case of Ms. Schabusiness, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
Sometimes longer if you have difficulty reading?
Could be.
So that was done. You reviewed some police reports in this case?
Yes.
A criminal complaint and some video footage, is that fair?
Yes.
Photographs?
Yes.
How did you get that information?
It was provided as part of the entire file. That's standard. It comes along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
Okay. And then you looked up some information on CCAP, the Circuit Court Access Program,
Yes,
basically a search on the internet of her background,
correct.
specifically her prior record.
Yes,
And then you looked at some Brown County Human Services records.
yes,
Would that be the Nicolay Psychiatric Center records?
yes,
So you looked at those?
yes.
And then you looked at some jail records?
I did not, I requested the jail records, but they had not been received.
And was there a request to see some Purveya health records?
Yes,
Did you get to see those?
no,
Did you review any Bellin health records?
no,
Was it your understanding that Taylor Schabusiness had some treatment stays at Bellin Health in the past?
yes, I understood that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment,
Okay. So you were missing the Bellin records and the Purveya records, correct?
correct.
Now, you got some relevant history, some background information about my client, correct?
Yes,
You found out that she was born in Chicago, correct?
Yes.
She was raised in Lindenhurst, Illinois, is that fair?
yes,
And then she moved to Green Bay in 2009 at maybe age 11.
yes,
And that same year her mother passed away?
yes.
Was it your understanding that her mother died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes,
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
yes,
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson, Mississippi,
yes,
then came back to Green Bay.
yes,
That's kind of the progression, is that fair?
correct.
You found out that she was also married in February of 2020.
Yes,
And when you were involved, had she given birth to her child?
yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Yes,
In Texas.
yes,
Did you garner information that she was in an abusive marriage with her husband?
what I gathered was that she was married. There was discord within the marital relationship, which led Ms. Schabusiness to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the nature of the relationship.
Did you get any information that her husband was hitting her in the head?
Objection,
No.
asked and answered. She doesn't know.
No, that's a different question.
Trying to plug it in. Plug it in, plug it in.
No,
Okay. So you got some background regarding her life, correct?
yes,
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
And was it such that she had some issues with school?
Oh, wait.
Suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
We did do 3 trials this year. That's what I was asking Diggs. I was looking back. Yeah, we did the Murdoch trial this year and Letitia trial. Both, I think they were both 6-week trials. Maybe that's what it is. I don't know, because the year before that, I think we did Alex.
The information that you have,
Alex, Johnny Depp,
as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year, though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, Doctor, upgraded your report by looking at additional records, Bellin Health, and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain, and I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Your colleague in the field is Dr. Matthew Seipel, correct?
Yes.
And did you confer with him with regards to, your opinions, your assessment, your evaluation?
No.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
Okay. That is something that could have been done, correct?
Oh,
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the issue.
Does it surprise you that, as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
Okay. You don't share information then, correct?
Only upon request, if it's appropriate, if it would be appropriate and permissible and specifically requested, but we don't, as a general practice, pass records between doctors.
Okay. If you had received these records, you could have done a supplemental report. Is that fair?
If it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
Now, as it relates to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes.
And was it your understanding that Taylor Schabusiness was committed and she was sent to that facility for, mental health treatment, correct?
Yes.
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Okay. Had you ever been made aware that she was under an order to take psychotropic medications?
No.
If I told you that she was civilly committed in April of 2021, where the court, a court of law, determined that she was mentally ill, would that cause you to have any concerns?
It would certainly be relevant, but it does fit with the information I already had, that Ms. Schabusiness was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No.
Did you know that she was required to take antipsychotic medication?
Yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
Now, during your 2 contacts with her in October of 2022, did you get a sense that she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering from a mood disorder when you met with her?
Her emotional expression was odd when I met with her, but I would, she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1, correct?
Yes.
With psychotic features, is that correct?
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Did you notice that Ms. Schuabusiness was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
How much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then, doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Okay. Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use? Same thing?
I'm less certain about that.
Okay. Certainly if you're using heroin or cocaine or drugs like that, that can cause brain damage as well?
Yes.
When you met with her, you did find that she exhibited some psychotic symptoms. Is that fair?
No.
In some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
No, and then to be clear with your last question, I did not personally observe psychotic symptoms during the moments of my evaluation of Ms. Schabusiness, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you. Did you see in the records there was a recommendation for her to be on Haldol?
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes,
Dr. Seipel was asked to opine on the competency issue, correct?
that is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes,
You had a chance to review Dr. Layton's report. Is that fair?
yes,
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
yes,
And do you agree with her findings?
no,
You would agree that Dr. Layton's report is more current than yours. Is that fair?
well, it was authored more recently, but the authoring of the report has little to do with its relevancy because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's because mine was in closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at it is your, with due respect, your report is lacking because you don't have you haven't reviewed the Bill of Health records, correct?
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred in 2022 to be requesting records from when one was a teenager. Those would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Schuabusiness tell you that she had no memory of the alleged offense?
She
tell
did.
you? When did she tell you that on both dates? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when she reported the amnesia.
That was on October 21st of 2022.
Yes.
And in reviewing those Nicolay records, it's true that she was hospitalized, correct?
Yes.
For about a month, right?
A
A couple weeks.
Somewhere
weeks.
between a couple of weeks and a month.
Okay.
The other guy
And
corrected
that
me, 3
she
weeks.
was prescribed some medication for nightmares.
I believe that she was prescribed Abilify.
And
I can
go ahead. I
refresh my recollection.
apologize. Page 3.
Thank you.
Chris Farley, legend. Movie
Okay,
reviews. I
sure.
never watched
She
that.
did say Prazosin for nightmares.
Okay. And it was such that when you talked with Taylor Schuabusiness that she was actively hearing voices, those were the comments that she made to you?
Yes.
Did she indicate to you that she was hearing voices, in her cell?
Yes.
Who were they of?
I think she was less clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing a voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
Extreme mood, like throwing a chair at a doctor?
Trying.
What I gather that you're referring to is the evaluation of Dr. Lighton of
Yes.
Ms. Schabusiness. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
That boy trying. Impulsivity, yep. No inhibitions. Sporadic. They go times where they don't want to sleep at all or they can't sleep. Either really high highs or really low lows.
Did you have the occasion to review the report from Dr. Tracy Lucetta?
No.
Trying. At one time, she threw a chair.
This is a yes or no. You could have gone back to see Ms. Schuabusiness after October 21st of 2022. Is that correct?
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
Why not? Who's yawning? Oh, somebody
The
yawning.
fact is you didn't, correct?
That is correct.
Did you see, when you met with her in October, did you see her use odd or unusual facial expressions?
Yes, I believe there were instances of her smiling inappropriately.
It didn't track or it didn't follow, correct? It was out of context, is that fair?
Yes.
Okay, I have nothing further. Thank you.
Redirect, Mr. Saunders.
Doctor, I want to pick up on questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time, and then that would be based on my experience that they can last as long as months.
Yeah.
Oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episode. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of chair throwing was a manic episode. Is that what you said?
Yes.
And can you explain why?
There are many reasons for a person to throw a chair. One of them could be due to a manic episode. But before I would make that conclusion, I would want to have compelling evidence that such a diagnosis is appropriate. And that would need to include objective evidence, meaning observation over time when a person is not being thinking that they're being viewed, things of that nature.
Okay. So I guess then would some of that objective evidence be to consider time periods both before and subsequent to the manic episode that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that can be gathered by looking at behavior over time. When is the onset? Does it happen? I mentioned this earlier. Does it happen when people are not being when they do not know that they're being observed, things like that. And then there's more, the more objective evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Schuabusiness, about her reporting or endorsing that she was hearing voices. You remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them was that they were represented some social anxiety, some rumination, her thinking about her circumstances. They seemed like more of an internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication, maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for you observed in Schuabusiness?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bell and Health records. You were aware that there was a prior attempt of self-harm previous in Mr. Business's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Schabusiness's use of methamphetamine at the time of these offenses, and I don't think that information generated 10 years prior would change that. So in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Ms. Schuabusiness's records in the past. Is that fair?
Yes.
And are you aware of any of those symptoms that were reported absent the context of methamphetamine use?
No, I am not.
And so like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
And then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No. My understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI 3.
Thank you, Doctor. Nothing further.
Anything on those topics, Mr. Freilich?
Did she say that she had concentration issues?
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
didn't give a lot of information, correct?
I disagree with that. I obtained a reasonable history from her.
Okay. It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Okay. Nothing further.
Anything on that?
No.
Thank you, Dr. Eustis.
Thank you.
Any other witnesses from the state?
No, Your Honor, the state rests.
Any rebuttal testimony, Mr. Freilich?
No.
Okay. Ladies and gentlemen of the jury, the evidentiary portion of this case is now closed. So to give you a sense of what's next, it's similar to the process that you've already experienced, and that is I'm going to instruct you as to the rules and the law that you need to apply. The attorneys will make their closing arguments, and then you'll deliberate. I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up, so I'm going to excuse you at this time. All rise for the jury. Be seated. So, counsel, I want to address some of the issues that you raised before when we were talking about the instruction. I don't have a problem delivering the instructions before you do closing arguments, and so I would probably take 160 and move it. And I want to just indicate the reason that I had proposed that is for this reason. When I look at 605, the last two paragraphs in 605 seem very similar to 515, which is read after the closing arguments before the jury goes out. And so I was looking for something as a way to kind of conclude the matter, as opposed to the last argument is made and I just say, go. So my suggestion is, if I read the instructions in the order that you've proposed, other than moving 160 to after 605, other than that, I'm proposing that I give a modified 460 just before the jurors leave. So after closings, I give a modified 460. 460 is the instruction, and I'm having my judicial assistant draft that up. That's the one that says something as follows, and I know you gentlemen have heard it before. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. It's that instruction. And the only thing I would eliminate is the second paragraph of that instruction, which says, you are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. I delete that paragraph because, first of all, this isn't a question of guilt or innocence at this phase. And secondly, because they're actually informed about the consequences of their action when I read 605. So I think that paragraph should come out. But in exchange for giving the instructions before you close, my suggestion is give that modified 460 after your closings. I then swear the bailiffs and send the jury out. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. I gave you the proposed verdict forms, and what I noticed as I was looking at them, there's spots for the dissenting jurors to sign, but there was no spot for the foreperson. My judicial assistant is making that change. So what I'm going to do is I'm going to go make these revisions and then bring them back to you. But there are a couple of other things I need to call to your attention. First of all, a change that I made in 100, the opening instruction, is in the third paragraph. You should have that. I put it in bold. That if any member of the jury has an impression of my opinion as to the issues in this phase, disregard that impression. That would take the place of the language that's given in the first phase, which is, if any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty. So I switched that. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then Mr. Freilich, I need to speak with you, and perhaps you need to speak with your client about whether you want me to give 315. That's the instruction that your client, during the first phase, elected that I give. That's the instruction that says a defendant in a criminal case has the absolute constitutional right not to testify. And that's really, she has an option to have me give that or not give it.
Come on, pimpin'.
Talk to my client. We both agree that you could read 315.
You're asking that I give that?
Yes, I am.
Mr. Business, you've had an opportunity to speak with your attorney about that decision?
Yes.
Okay, and I know you spoke with him about it at the beginning of the first phase. You'd like me to give that instruction in this phase?
Yes.
All right. I'll give 315. 640, mental disease or defect expert opinion testimony. The interesting piece there is that the last paragraph, the court has appointed, and then it says to fill in the name. Two of the people that were appointed by this court testified. Only one on the NGI piece, but two of them testified, and they both testified they were court appointed. And it indicates that you shouldn't give give their testimony any greater weight. I think probably both of their names should be in there, but I could see an argument that only Dr. Engen's name should be on there because she was appointed on the NGI. On the other hand, they were both appointed by the court, and the notion that they shouldn't be given any greater weight than anybody else seems to apply to both of them. Mr. Saunders, any opinion on that?
Not really. I guess the preference would be to include both.
Mr. Freilich?
It would be my position that we would only use Dr. Christina Engen because she's the one that did the NGI evaluation.
Okay. I'll just give Dr. Engen's. We keep pronouncing her name differently. I've heard it pronounced both ways. Is it Engen, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Engen, I think.
All right. That's how I'm going to pronounce it. Moving on then to 605, there are some options that we need to address. And that is under the subheading meaning of mental disease or defect. I have some thoughts about which ones seem appropriate given the evidence, but let's just run through them. The first option is, because it indicates that in that particular portion, add the following if supported by the evidence. First, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I do.
That'll be out. The next one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included. Particularly well, there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear anybody, a doctor or professional say anything about antisocial conduct.
Was applied.
So I would object to that.
I'm going to give that instruction for this reason. There was
So,
a lot of testimony.
And the three diagnoses you offered, you said.
That's going to be the order of the court. The next one, voluntarily induced state of intoxication by drugs or alcohol.
I was thinking of doing that,
Mo.
Mo.
Constitute a mental disease or defect. I note that the parties stipulated at the last phase that should come in. I'm assuming that's where we're at now. But Mr. Saunders, you're asking for that?
Yes.
Mr. Freilich?
I mean, not Facebook, Twitter.
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's doubling up.
Duplicitous.
The paragraph before is, I think, says enough. It's mentioning it twice, basically.
So,
well, I think the difference is voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking, and I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way?
That's all I hear now is the ums.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect.
Lord Almighty, what are we gonna do?
I was just saying it a different way, in my opinion, my humble opinion.
Oh, let me not do that.
Mr. Saunders, any response to that?
yes, I think they're pretty clearly different. A voluntary induced state of intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection, is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis. So not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different, so I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this language should come in. The court should consider it. I asked, I believe, Dr. Engen and Dr. Seipel, and I believe Dr. Layton, that using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor?
Yes.
It's crystal clear to me that this should absolutely come in. This young lady, Taylor Denise Schuabusiness, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often. She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment, and it was clear, the records replete with the fact that she had a chronic problem with meth, methamphetamine, marijuana. So I think it's totally on point, and that should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
I think the focus is if the condition has become permanent, and whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case.
I was wrong. I thought it was going to be a quick thing as far as this part.
I'm satisfied in light of the state of the record that it ultimately comes down to what the jurors heard. There has been a great deal of testimony regarding the use of drugs or alcohol. There were some questions placed to the defense expert about impacts on a person long-term using various drugs. I'm satisfied the jury can assess that. I'm going to give that instruction. Certainly the parties can argue that they don't believe the evidence supports that particular aspect, but I'm going to give that piece. So I'm going to include that. And then that's the last option that has to be selected. I'm going to make these revisions then, and then I will give you a final copy of them, and then we will move, we'll bring the jury back in, and we'll move to instructions and closings. All right, we are in recess.
Thank you.
Hey, wait, what are they going to do? Tammy says, thank you for the super chat. If she's not insane, nobody is. What? So they're in recess. I guess they're going to do the jury instruction. So I guess they're going to put it together. We're sipping the water. There's a guy. There's a guy in the blue shirt. So what's up with him? Is that undercover or something? Clones. We see you, buddy. We know you're there. You're wearing the same shirt you had on yesterday. Unless he just has a closet full of blue shirts. He could too. That could be a thing, right? There's people that just have like, my favorite shirt. I'm going to wear this color, shirt, and type forever. So it's like a closet full of blue shirts. It could be that. So yeah. Fuck my life. So I think that they're going to do the verdict, or they're going to do the jury instruction when we get back. They still got to do closing arguments or statements. They still got to do that, which I don't think is going to take long. And then the jury, we could be done today. It's almost 5 p.m. here now, Eastern. So it's almost 4 p.m. over there. They still got a lot of time. Let's see how many hours we've done today. It's probably going to be at least another 10-hour stream, close to 10 hours, if not 11, maybe. I don't know. Let's see. The other one was 5 hours and 30 minutes. And we're here now 2 hours. So 7 hours and like almost 45 minutes. So we're getting maybe actually even more. Yeah, close to 7 hours and 45 minutes, I think. Creeping up on 8. We did almost 10 yesterday, so there's still plenty of time. I think they'll run this up till if they can get it done today, they'll be done with it today. So I thought yesterday this was going to be a couple hours stream would be done, but I feel like I want to sneeze. It's not coming out. If you guys could hit the like button for me again. I know you've done that already today. We got disconnected earlier. So I appreciate you guys. It's in my head. Appreciate you guys coming back. You could be anywhere, long crime or the attorney streaming. I know. I think I saw Emily on. But I was eating this little. I bought these snacks the other day. These, I don't know, Orchard Valley Harvest. It was like these little like nuts and like cranberry, some chocolate in there. I gotta do groceries. I spent a whole lot on groceries the other day, and it's like the meats and snacks are gone already. I don't think she's gonna do a violent outburst. I was kind of thinking at first. By the way, she has a shock belt on or something like that. She has a shock belt on, and with this poll, so far 1,408 people have voted. 28% say it's gonna be mental with disease or defect, basically saying that she's insane. Maybe I should have put the more easier. It could be a little confusing to read the poll. It's basically insane or not insane, not guilty due to insanity. 72% saying she's not mental with disease or defect. Like 200 calories. I know this stuff, man. I don't know what I'm going to do about this trying to lose weight thing. I had pizza last night, too, to be honest with you. Had some pizza. Going to hell. And I ate pizza this morning, too. From last night. And then I had that turkey meat. Okay, let's see what's going on. Let's see what else we got. They're coming back soon. Maybe we'll be done today. Oh, let's watch that clip again. I thought about it sitting here and like editing this thing and putting something together, but Mo did some of it. Or witness.
Was applied
and the three diagnoses you offered, you said.
Virtually similar,
I can't unhear it now,
indistinguishable from a manic episode with psychosis.
Yeah, I can't stop hearing it now. You already got editing down. The jump cuts, the basic stuff in editing. Yeah. I made a tweet because I put the tweet of her clip out. I had to delete it like 3 times because I put Taylor Schuabusiness, trial witness, Mo. Initially, I put chop this up, but then I was like, let me just delete that. I was like, clip this because I'm thinking of that guy, the witness. But I feel like people that don't understand the trial and the context are gonna try to cancel me. So I was like, I'll change it. Let's see, what else do we got? They almost took the stream down, by the way. I think by playing one of those commercials, they almost shut it down, saying a copyright detection was going on. That clip reminds me of, I really thought about doing that because it reminds me of this other woman. They had this weird sound effect going on. Megan, this is the mother, Megan Boswell. She had this weird like sound that she was doing. Can we mute Mel? Your sound glitching? Am I glitching? Testing, testing. You know what? It should be fun. Let me get some of the super chats as well. Let's see. Chrissy, thank you for the super chat earlier. Welsh Dragon, I think I missed this. So unnerving. when she stares straight at you. Complete psychopath. Can you imagine Taylor and Letitia as cellmates? Yeah, a few times I saw her facial expressions. Like I was saying, it looks like she's looking directly into the camera. Kind of creepy. And it's a very intentional thing. When you have cameras pointing at you, like this little camera here now, I intentionally like have to look up and like directly into it to like look at you guys, or else I'm looking at the computer and the chat and everything else. Laura wrote, and thank you for the super chat. It says some of them are used for major illnesses called a lot of involuntary movement, weird mouth, or their tongue is too big. I know that sounds crazy. Tammy, I got that one already. Welsh Dragon, I got that. Jory, thank you for the membership. Cassandra, thank you for sharing on Facebook. Christy, I got you. Thank you for the super chat. Bonnie, thank you for the stars on Facebook. And let's see what else. Bug Love, thank you for the 4 months. Thank you for making this bearable. Wimbles, don't F with Wida Bears. Thank you for the 3 months. Okay. Thanks, Mel. 3 months and 19 days on gifted membership. Thank you so much for resubscribing. Melanie, thank you for the 5 months. That time went quick. Tammy, thank you for the 2 months. God bless her attorney. Not me. I would have been scared. Welsh Dragon says, love your wall art. It changed depending on the light reflected. Yeah, I ordered that thing on a whim. It was a website. I think they're custom made. So like, I think there's only one per, like you can only get one and that's it. And there's like a bunch of different designs. So I thought it was kind of cool. I taped it to the wall. I used that stick thing, the tape stick thing. And it took me a little bit while to like adjust it and stuff, but thank you. Yeah, I wasn't sure how that was going to work out, that wall art. Let's see. Brenda B, thank you for the 3 months. So she's really calm today. Weird. She's calm. She's still making facial expressions, gestures, smiling. Elaine, thank you for the 10 on the super chat for the lotion. Thanks again for being fabulous streamer. The chatters and mods are awesome too. Thank you. You have some really good mods. Delphines handcrafted. Thank you for the super chat. Tammy, thank you for the super chat. If she isn't insane, nobody is. Tracy, not Tracy. Thanks for the super chat. Just sending love. Normally a lurker, but a faithful lurker. Thanks for all the good times. We're here and we're here and we're. Oh, it's like pouring outside. Let's see if I can do this. How do I do this? Let's see if I have time because they come back so fast. I probably don't. Let me not do all that. Let me just show you. This is what it looks like outside. Okay. Cloudy, rainy, all day. That's my nice little seat. I want to get another couch in that place. If I have company and then I want to be on camera, they can sit there. But that's Maddie's little spot there if she wants to chill. But yeah, cloudy and rainy. Thank you for the memberships, Christy and Ms. Deefy. Thank you so much. I think we'll be done today, like I said. And we've done. I don't know why it was kind of weird. Like I was dragging a little bit with this trial, kind of. And this is day 4. It's kind of odd, but the only thing I can think of was like this year we did more trials than last year. I think last year we did 1. This year we did the Murdoch trial, Letitia trial, both intense, long trials. And then we did now this one, which was short. Last year, I think all we did last year was the Johnny Depp trial. Johnny Depp, yeah, I think all we did was Johnny Depp. Get outside. Check out the naked woman on the highway in California. Lord. La la. You're good. Chrissy, no, you're good. Don't worry. I appreciate you guys being here, man. Yeah, the Ethan Crumley thing, I was thinking of streaming that. Probably not today, but if they finish with this today, maybe tomorrow. If anything been bipolar lately, it's the Western. The Western what? The Western woman? Just Western in general, Western. Oh, the weather. Okay. Never mind. Oops. The same in Bristol, England. Yeah, I think this is a wrap for business. Sled. I think it's a wrap. There's no way. There's not even like a question. Like I feel like the Murdoch trial, there was a question. It wasn't. Nobody really was sure of the turnout. Even some attorneys got it wrong. This one is like it's kind of crystal clear. Jesus. Children escape home naked and covered in feces. What the hell? That was 8 days ago. Lawyer, you know.
Again, I know it's still going on now. So a lot of people are over there watching the trial live and will be watching this later, which is totally cool as well. And you can throw your questions in the comments if you're part of the rewatch crew. But in my schedule, this was the only time that worked. So we will answer questions. We will do some recapping, and we are going to start with the verdict. And the verdict is obvious because we're in this phase dealing with the not guilty by reason of insanity. But I still want to watch together so everybody here can understand what happened, what she was charged with, what she was convicted of, and then we're going to go into the judge explaining this second phase. It's the same jury. He's explaining to them that phase one is over, and now we move into phase two. So you can see and hear the heinous crimes she was charged with and convicted of. No surprise. Everybody who watched saw this coming, knew this was going to happen. Very quick verdict. The interview was very damning. The facts of the case were gruesome and gory and very damning. And in most trials where you have this situation where there's not guilty by reason of insanity, the defense doesn't even argue with the first guilt portion of this situation. So the fact that Wisconsin has it set up that you can plead two ways, you can kind of put up a halfway fight on the first phase. I'd be interested to know how many times an NGI case with these two phases has been a not guilty verdict on the first phase. I would be willing to bet it is very, very, very low, very slim chances. So the fact that that happened should not surprise anyone. Like I said, in Florida, when this happens, the defense attorney just let the state put up the case, and then they wait and they basically bring up the doctors, which is what you're seeing in phase two. But here they split it into two. So let's listen to this judge now explain what happens here in phase two.
This is the second phase of
Okay, so we know this stuff already. I want to see a little bit of his reaction.
potential capacity.
They go first with the witnesses, at least in their case in chief. They call their witnesses first. So it's kind of interesting to have this flipped burden and interesting to kind of watch from a legal angle. But the judge just explained it. They have to prove to you with reasonable certainty by a greater weight of the credible evidence. So it's interesting that they put the reasonable certainty in there because by the greater weight of the evidence, obviously proving a case by the greater weight of the evidence means you prove the case by the greater
Yeah, he's a lawyer. I put the link to his channel. That's Lawyer You Know on YouTube.
weight of the evidence. What does adding reasonable certainty do? Because it seems like reasonable certainty would raise the burden of the greater weight of the credible evidence. this is probably behind or into the weeds a little more than you guys care about. But that's a very interesting explanation. I would like to know from the lawmakers why throw that in there. But then he explained that the mental disease or defect that they have to prove she has to actually have had the effect that she didn't know or she could not conform to the law. Basically, she didn't know what she was doing was wrong. We've heard this before. We're going to listen to it one more time just so we can have the right frame of mind as we talk about the rest of this phase.
Okay. Let me see. He has this new witness there as well. I saw earlier. Doctor.
This decision, she knows she made it. She knew it was wrong and she did it anyways. So, at the end of the day, we have one expert that says her opinion is she is not guilty by reason of insanity. Only one expert. The other expert said he wasn't there to opine specifically on NGI. So one
Opine.
Okay.
All right, let's see. Let's go.
All right. You should have now a copy of the instructions that I propose to give to the jury. And again, I will give this before closing arguments. I'll start with the modified 100.
AJ Vintage.
There's one missing.
I think sometimes it's more lucrative for some of the bigger lawyers to just do YouTube channels and give commentary. I mean, I think he still practices. I don't know, but I think at a certain point, it's probably more lucrative and less hassle to comment on YouTube.
Well, in any event, there's the add-on at the end of 100. But I'll get
I could be
to that
wrong
in a
though, but
minute.
I think it might be.
I'm going to give 315. I'll give 640, the mental disease or defect expert opinion testimony. 605, instruction on the issue of the defendant's criminal responsibility. Then I'll give 160, closing arguments of counsel. Then you can do closing arguments. And then the closing instruction 460 after you've completed your closing arguments. I've added the verdict form, and the verdict form actually needs to have the heading on it, and I'll make sure that gets corrected before it goes into the jury. But I did fix the request you had, Mr. Freilich. So the question one is, at the time the crime was committed, did the defendant have a mental disease or mental defect? And I did that for question two as well. And in the instructions, when I indicate you're going to be getting this verdict form, I made that correction there as well.
Thank you.
All right, so we should be getting closing arguments soon. Stay hydrated. Yeah, I need to get some water. He only does personal injury. Oh, okay. Daddy's big attorney. Deirdre.
You know what? I think what I was thinking was missing. I don't think it is missing. I was thinking 602 needed to be inserted in 100, but that's true. But in the first phase of the trial, and so I think that's where. I think I was thinking of 602, and 602 doesn't need to be inserted in 100 at this phase. Okay. That's what I propose to give, counsel. I'm going to start with you, Mr. Saunders. Any objection to the form of the instructions or the verdict form?
Just on the verdict form, question one, think it should read at the time the crimes were committed, plural, instead of the singular.
You're right. Because we're dealing with 3, so that can be corrected. And then when I give 605, question 1 at the time the crimes were. Any objection to that, Mr. Fairley?
No, that makes sense. Crimes were, that's what we're talking about.
Anything else, Mr. Saunders? Just the same thing.
Oh, there's one more instance. In the top of 605, the defendant's mental condition at the time of the offenses.
Sure. Makes sense as well. Mr. Fairley, any disagreement with that?
Your Honor, are we talking 605, the number 1?
605, the very first sentence says, you have just heard testimony about the defendant's mental condition at the time of the offense, and they're suggesting it should say offenses.
I agree.
Anything else, Mr. Saunders?
I guess it's also on the next page, the first question heading.
Oh, man.
Well, it's on that same page, number 1. At the time the
Prosecution
crimes
on
were
point.
committed.
I like Judge Newman a lot too. Still gotta do closing statements too.
Okay. Those are fixed.
Who wrote this? Chat GPI maybe? No, even Chat GPI.
I don't think
Whatever.
it appears any other place.
Imagine they doing that in the
Anything
trials
else,
now.
Mr. Saunders?
Asking Chat
No.
GPI to write it.
Mr. Freilich, anything concerns about the form of the verdicts or, the form of the instructions or the verdict?
Your Honor, I see what Mr. Saunders was talking about on that second page, where it's in writing. The first question is, and then it should say at the time the crimes were committed.
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says 2 questions, and then it's got question 1 and question 2. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just wanted to make sure.
He's trying to get brownie points.
Thank you.
Time's passed
So
already.
everyone
Time's
knows,
over.
I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings. And so when this is delivered to the jury, they will have it corrected.
Okay, thank you.
In addition, as I've indicated, I'm also going to have the heading inserted on the top of the verdict form. So instead of the title of 605B, which is where this verdict form comes from, it'll have the heading of this case.
Trying to search
If
for
there's
it.
nothing else then, I'm going to use the same time limits as we had yesterday, but they're
Let's
going to
go.
be flipped.
Don't waste
So
time.
yesterday I gave the state a half hour and 10 minutes of rebuttal. That's what you'll get, Mr. Freilich, but the state will get 35 minutes for their closing. I'm not sure if you're going to need that much time. The time that I've given everyone each time, they haven't used, but I will keep track of that for this time.
Okay.
Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank you, Judge.
Very good. Let's bring the jury
Bring him in. Let's do it. Hey.
Which microphone are you using on the call? That one?
Sure.
Right, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question, yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect.
You lost. That's it.
A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offenses were committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments.
Closing arguments, baby.
As indicated,
let's go. We're almost done.
Burden of proof in this case. Mr. Freilich will start. Mr. Freilich, are you prepared to make a closing argument?
Yes, Your Honor.
Go ahead.
Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. Now, the question is whether or not Taylor D. Schuabusiness is legally responsible for the crimes that she's been convicted of. And in this case, Taylor Schuabusiness has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form.
I will.
This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engen, and we have Dr. Leighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems growing up as an adolescent, that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center.
You have the same thing when you abused that child?
My client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home and she was there. And that was I would submit that was a pivotal event in her life because she loved her mother. Then we moved on to Dr. Diane Leighton, PhD, a doctor, forensic psychologist. And she provided testimony as to her extensive background, her training and experience. And she provided testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of doctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997, she went and became an independent forensic psychologist where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship. And so she testified about her background and her resume. Lawyers call it a curriculum vitae, her CV. Bores out all of the experience that she has working in this field, technical field. And she went on to testify about the fact that she met with Taylor Schuabusiness in February of 2023 at the Brown County Jail, and Ms. Schuabusiness was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. Schabusiness in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County Jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records, looked at the Bellin Health records, looked at a lot of information. Basically what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engen, she's the one that did the NGI evaluation.
It's like no drive.
Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Schuabusiness, Taylor Schuabusiness, qualifies for the NGI plea based on her diagnosis of a serious mental disorder. The serious, she opines, she concludes, that the serious mental disorder affected Taylor Schuabusiness's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health. She also says and opines that Ms. Schuabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year. there was some talk about the feigning, the faking, the malingering. Feigning means faking. About that topic. And Dr. Lighton indicated that it was her opinion that my client was psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Schuabusiness had a problem with methamphetamine, with drugs, marijuana, other drugs maybe. Dr. Lighton says that Ms. Schuabusiness had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that. But she opines that her assessment finds that Taylor Schuabusiness has a genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engen, with respect to her, she didn't know that my client was under a civil commitment order for Brown County by Judge Lee Joyce. Taylor Schuabusiness was found by the court to be the subject of a civil commitment, and that's why she went to Nicolay Psychiatric Center. My client was also the subject of an order for voluntary medication. She had to take medications ordered by the court. No ifs, ands, or buts. Why? Because she was deemed to be having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account. That in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill.
Let's go, man.
When you look at, the report from Dr. Seipel, or you heard about his testimony, I would argue that, his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately.
He was the most gangster one.
His focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with, and that is to determine if my client is NGI, if she meets that criteria. Dr. Seipel, although he's a PhD, his training and experience is much less than Dr. Lighton's. But his focus was competency, and that's not why we're here. Dr. Engen, she testified, and she met with my client on October 12th, 2022, and then again on October 21st, 2022. It appeared that on October 12th of 2022, there was some security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale.
Oh,
she didn't receive spelling records. She didn't look at those records.
Hell no.
Someone else could have given her the records. Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors, which is something you should consider. There was no connectivity there. Also, with due respect, Dr. Engen, didn't trek from Milwaukee to the Brown County Jail to meet with Ms. Schuabusiness to do further assessments or supplements. Didn't do anything to supplement the report. So that's something you should take into account as well.
Too respectful. You get like down and dirty with this shit. I mean, it's nice. It'd be a little bit dirty, man. Huh? Ratch to get out of this hole you're in, man. I mean, he's did all right to try to represent this really hard case.
There's an instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here.
The other lawyer got attacked, so this is what's left. He ain't do bad, I guess, right? The other one ran off. She ran the other one off.
We believe that Dr. Layton was very clear that Taylor Schuabusiness has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear. She talked about the fact that Taylor Schuabusiness heard the train, heard the whistle, that Miss Schuabusiness lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale, that she has a very unusual presentation. And she testified that Taylor Schuabusiness, when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions. But Ms. Schuabusiness was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr. Litton talked about hypersexuality, and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Ms. Schuabusiness was washing her hands 30 to 40 times or touching her hair, things that were a cause for concern.
Things that all women do?
Wisconsin law, we all have to follow the law, and Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, that Ms. Schuabusiness had a mental disease or mental defect, and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just 2, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request that you consider that, and that it was bipolar 1 disorder based on the testimony from Dr. Litton. Then number 2, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Schuabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that that would be a yes. And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Schabusiness's mental condition at the time of the offense. So take that into account. It's a difficult case. It's a very complex case. Deals with law, deals with psychology, deals with mental health. A lot of things going on. But I would ask that you take all of this into account when rendering your decision. Thank you very much.
It's been even stretching out, like looking up at the ceiling and shit. All right, so we got now the other people. Prosecution.
You're going to be giving Saunders. Okay, go ahead.
See what they got. I guess they probably get to do rebuttal in defense. You know?
I think it was the dope. I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand. She even talked about how she was still tweaking on meth during the dismemberment process.
Oui.
Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth, and now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis, but there's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. And you also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that. Instead, we're relying on a bipolar 1 diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court-appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion, and that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate if this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct, right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. And you heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case.
Let's get a second opinion.
Based largely, her opinion is, on her interactions with Ms. Schabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off, right? So this idea that Dr. Litton's opinion based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball, right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert, Dr. Engen observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony, for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Schuabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. Didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. As he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert. And You heard the testimony, and if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or have a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, you get to the second question. Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense, and really it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too, but it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes, where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor. I mean, what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over? Yeah. She said yes. And why did she say it? Why did she say she did that? She was covering it up. Right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it, because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct? She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. And now we hear this professed amnesia in her comments to Dr. Engen about this offense. And you saw the interview. She had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, and you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? It was pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up. because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law, and again, you heard nothing from Dr. Litton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so. And she did. You heard about her saying, well, yeah, I knew I was killing him, but quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect. We heard about the burden of proof, that it's a reasonable certainty by the greater weight of the credible evidence. And you should be, even though it's not our burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by the greater weight of the credible evidence that she does. And it's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. If there was additional jail records, they could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right?
Yeah.
You don't really care. You're not asked to decide, does she have mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing a parent at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. Now the meth really didn't have anything to do with it. It's important to note, a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.
Mr. Fraley, do you have a rebuttal?
Yes, I do, Your Honor. Thank you. Your Honor, again, may it please the court, ladies and gentlemen, Mr. Saunders, Mr. Lissay. You know, this case illustrates that this young lady, Taylor Schabusiness, has a lifetime of mental health issues. She has bipolar 1 disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease, that predated the incident that has brought us here to court on February 22nd of 2022. It's clear in this record that Ms. Schabusiness was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month, in 2021. You got to see in phase 1 of this trial, Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. Schabusiness Officer Russell met her at the door, out on the porch. And you could see on the video her face. You could see her eyes You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on. Did this happen when she was in a manic state or a psychotic state? I submit that, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life.
Enough of that shit.
What we have here is someone who has a very serious mental health issue, mental health disorder. And you pile drugs on top of that. It can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay, she was under a court order where she had to have injectable antipsychotic medications.
And he's mentioning that it's injectable versus like a pill, by mouth pill.
She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here. She has ongoing mental health issues, and she's only 25 years old. And they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation. And that'll be something you have to think about. Is she able to appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it. It was very bizarre, very unusual, very odd, her demeanor. In this case, there are a lot of doctors, but Dr. Engen, she never knew about the civil commitment order. Come on. You didn't know about a court order? And she's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't know about this civil commitment order or this medication order. And then we have Dr. Seipel, he got the Bellin records, got them from me. And, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engen, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable. I don't make the law. But the law, the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that. The defense didn't fail. There is a plethora of evidence to show her mental health history. Was her bipolar 1 condition permanent? I submit to you that it was. Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Roth, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Schabusiness lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and Shad were buddies. Words to that effect. So I submit that she did not want to do this. At the time, was she in a state of psychosis? Who knows? That's for you jurors to decide. But we've presented the lawyers, Mr. Saunders, Mr. Lassay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess.
You guys heard that?
I would ask that you consider the fact that Ms. Schuabusiness was taking the antipsychotic meds, the injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition.
Maybe.
If you don't take your high blood pressure medication, what's going to happen? Your blood pressure is going to go up to the sky and you could have a heart attack or stroke. Same thing rings true for other medications.
Taking medication with alcohol.
And in this particular case,
drinking wine, popping shots, taking
Ms.
meds.
Schuabusiness did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff. I would submit that based on everything that's been presented, I'd ask that you consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
Right.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
Okay, yeah, we gotta do okay, hold on. We gotta run the timer first. Did they leave already? They leave it now? Did we start the timer now? They're leaving, right?
Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court?
How much for a short day, huh?
Before they render their verdict,
Let me get you a new
communicate to
timer
any
too.
person
I mean, a new poll.
the state of their deliberations or the verdict they have agreed upon. So help you God.
I do. All rise for the jury.
I don't know if it's like super long days or it's just that we've done more trials this year. Kind of exhausting this time. I don't know why. All right, give me 1 second, guys. I got a poll coming along. They're leaving now. Along for verdict. We'll start at 30.
Before we recess, Mr. Saunders. No. Mr. Fraley.
No, Your Honor.
All right, then I'd ask, as with the situation the other day, I'd ask if everyone remain around for 30 minutes until 6 o'clock or so. After that point, if you want to leave, if you could just leave a cell phone number where we could reach you. And with that, we are in recess. Thank you.
Okay. Okay. Okay, so we're doing the. So let's go with, we're going to put 30 minutes, 1 hour, 2 hours. We only get 4 options to put. 30 minutes, 1 hour, 2 hours, and then I'll put more. I ran the timer. I think the reason I think less than an hour. I don't think it's gonna take these people more than that. Yesterday, I started 1 hour and then I moved to 2 hours before they came back. Just thinking maybe to give them extra time. Oh, look at that. We're in sync. What? That is gangster. Oh, we're in sync. We're in sync with Law and Crime. And yesterday they took less than an hour. I think what did they say? Yesterday was like 40 minutes or some shit. I think it'll be I'm gonna go with you guys, 30 minutes or less. I say 30 minutes or less. Yesterday I think it took about 40 minutes, right? Oh, what's up, Blair? How you doing? I think they probably discussed most of this yesterday. Yeah. I don't think it's even gonna be a thing really today. This whole thing's already discussed, even though they're supposed to be taking into consideration today's stuff. I don't think today's stuff changes much. You know, I just did some groceries online because between this trials taking the entire day, you have no time to do shit. It's the fuck, yo. I mean, listen, the judge is doing a damn thing. They're trying to get this done too, and really, the people there in person are really the people that are going through it. 42 minutes, BL says. I'm not sure why this trial feels a little kind of, maybe I'm not taking the appropriate breaks. That's the thing though, with the Letitia trial, I managed pretty well through it as far as like being tired or not, which it's always weird to me. They're like, okay, I'm here sitting at the desk. Why the fuck am I tired? But I don't know what it is. It just does, man. You just, I think the prolonged hours of just sitting here, I don't know. My ass, even though I got this cushion thing, my ass starts to hurt. I think it's just taking the breaks and walking around. I think the Letitia trial, I had in mind longevity, and I knew it was going to be like 6 weeks. So, and that trial itself was draining. That trial, there was clips that I still haven't posted to this day from that trial that I thought were like, there were some funny moments. There were some really horrible moments. The last part was the worst. I think the end, we all cried. That was a crazy tell. Letitia stalked the stepmother that killed her stepson, Gannon. That shit was fucking exhausting, bro. That shit was emotionally too. That's the thing with that one. The funnest trial I ever did was Johnny Depp. I really enjoyed doing that trial. That was a lot of fun. Murdoch was pretty good too, honestly. Murdoch trial was kind of fun. Let me see. Did I order this stuff? I think I ordered it. I mean, I did big groceries the other day, so I just ordered what I need for the house. It's thundering outside like crazy now. Hopefully the connection doesn't cut. The end of the world. Yeah, Maddie's here, which makes it even harder. She's really good, though. But normally she's in school, so like it's easier because majority of the time she's just in school. So then I pick her up for lunch. I mean, I'll usually take the lunch break and I'll pick her up from school, and then it's just a few hours. She's here the entire time, and her mother was supposed to take her. That didn't work out. And the other day I was going to take her to my mother's, but she wanted to stay here. She didn't want to go over there, so I just kept her. My mother came after and did her hair. I think that's the other reason why I kind of picked like a short one while she's on summer break. It really depends with some of these trials, man. The thing is, the Letitia trial, outside of the horrible shit, that was actually a really good trial. Like the Letitia trial, like every day had something, you know, like that was like, holy crap. I think there was one day where it was kind of like, wow, this is kind of slow. It's dragging. Every day that trial had something you were like, oh shit, whether it's like body cam or Letitia or whatever. That trial, they kept the pace going, and it was pretty. It just worked out with that trial. This one kind of had its moments, kind of dragged. I feel like, and I think the only bad thing I did in that trial, I think there was one day where we were waiting for the verdict, and I think I left the computer. I was stressed out about some shit going on personally, and then I had a drink. That's why I really don't like to drink while I'm streaming. Like, I mean, we'll do the shot sometimes, or like I've had those streams where I've had times where I've drank, but I prefer, especially like trial stuff or law, I just prefer not to because I don't want to get out of character. But there was that day during the trial when we were waiting for the verdict, the jury didn't have a decision, right? And I heard about that, so I came back and I was like, snapping, what the fuck? I was pissed because of the shit that I was dealing with, but then I just took it out on the jury type of thing, which was kind of ridiculous because they really have the right to take their time and decide or whatever. But I was kind of pissed because I was just thinking like, fuck, like these people really, it's taking them, they really can't decide about this Gannon stuff. Like they're really like thinking about this shit. Like what? That's why I kind of snapped. I think I just unlisted that stream because I was like, that wasn't good luck. Not even that. I clipped that part of me snapping and I posted it too. I posted that clip. And so I took that video down because I was like, it's not becoming of me, It's just, I took that shit down. I don't want to do that kind of stuff, man. But, I was just caught up in the shit. That was after, was that after or before the crying? I think it was after. So that's the thing with this trial too. Like this is not gonna be done today. So hopefully we'll get a verdict today. But we still got to do sentencing, and if the family's gonna do like impact statements, we still got to do the impact statements. So yeah. Would anyone like to put me up on? Let me see what this says here. Lost the chat. Something about Sarah Boone. Okay, Melody. Would anyone like to put me up on the Sarah Boone trial? I can just disappear from home for a week. So that trial keeps getting pushed back. I really wouldn't plan too much. That trial has been pushed so many times. Let me just see if I can find another date when they pushed it back. It's been pushed 6 days ago. Sarah Boone trial date, new trial date set. It was for, now it's been pushed back to September. So, I mean, I can't even count how many times that trial's been pushed. We're all waiting for it. I mean, I don't know if she can try to say, like, these people are not, isn't there some type of rule or some type of, like, she could say justice is not being served. Like so many attorneys have quit her case, I think, and the date has been pushed back so many times. I don't know, man. So again, yeah, it was supposed to be. It was supposed to be, I think, July or something. Or we're supposed to be October, I think. That's what I was telling you guys too. Like, I'm not even worried about that shit because it was supposed to be October 2nd. Everybody's like, oh, it's the Koberger stuff. And I was like, yeah, I'm dealing with today and tomorrow. I don't even really stress out about that shit. Like, whatever happens, happens. The dates keep changing. Anything could happen to who knows what tomorrow holds, right? So, iCkEdMeL, you're a sensitive empath. Well, I used to, like, back in the day, when I used to cover some of these stories, like Malia Davis, I remember even with that story, I kind of went off the handle. I was snapping. I cursed out. I think I said something about the parents in that story, which I took it down. But, like, I used to, now I'm kind of more chill, but I used to really get pissed with some of the stories and just, like, go off. My loyalty rare, like a skinny girl knowing how to cook. Oh, man. Well, kind of these days, almost finding a woman that cooks. Not that it's rare, but like you'd be surprised. A lot of women don't cook or whatever. You'd be like, what? I'm not saying that they have to, but you'd be like, damn, some of these people living on their own, you'd think they would know how to cook, What do you eat? I thought about that, Jody, multiple times, looking into Alexi Treviso. Rabbit was telling me about that story. She's covered it. I just haven't had a chance because of this trial. And then we had Carly and we had Rudy, all those fake situations. I mean, I don't know about Rudy. Seems like it. And now we have this girl, Alicia. I think Alicia, not Alicia Navarro, but the other woman. And Alicia Navarro is found safe, which is, I mean, that's not. I'm glad she's safe. The circumstances, I don't know either. It seems like she ran away willingly. I think that's what cops said. She left on her own. I guess they're gonna have to investigate. What happened to my card? Oh, there it is. Continue shopping and never finished. Let me finish it. I remember one day I thought I finished it and the shit never came. The thing is, like, Maddie's eating a whole lot now. I guess she's, kids go through their growth spurts. She eats, like, I almost think more than me. And she's, like, petite and skinny. Yeah, let me finish this crap. And then school's coming too. You don't cook crimes that have consequences. So what do you do? How do you just like kind of microwave stuff or take out? You don't cook at all? Winston says I like cooking, but not every day. Yeah, it's exhausting. Yeah, to cook every day. I mean, I made that turkey which lasted like 2 days. The other day I had what we do? The other day we had the salmon, the gangster salmon. We had a whole conversation about wild caught salmon and like the color, which is kind of funny because I had a friend that told me she prefers farm raised salmon. I was like, what? Because she said that farm raised salmon isn't as fishy, like the taste and smell, which is kind of true. I did notice that. We had a whole thing about this the other day because I was in the store and there was this one here, salmon select cuts, fresh, never frozen, color enhanced through the feed, which I guess the food that they feed them gives them a little bit of that color, because apparently the reason the salmon have the color is because of normally they eat I think it's krill and some other food, and there's something called, I forget what it's called, carotenoids or something. They get their color through the food that they eat. But because these farm raised salmon are being fed pellets, they're not getting the rich color that they normally get. And so this is what, like, it can be like orange, reddish, this is what they act like, a bright, darker color like that. Those are the wild ones. The reason this one's cheap, $10, is because it was on sale. That sale's over now, but yeah, I bought this. It was amazing, but it does have more of a little bit of a fishier smell and a little bit of a fishier taste, kind of. But it's so freaking good. Oh my god. Cooking is my escape. I cook. I sometimes like cooking or like just trying making different things, but a lot of the times I feel like I'm kind of rushing because I don't have time because it's YouTube stuff. But if you get an air fryer, I feel like air frying is the cheat to cooking. I feel like you don't have to know much. You can just throw whatever in there, season it a little bit, and throw it in there, and you get some really nice meals just from the air fryer itself. Salmon is naturally pink, by the way. It doesn't tell if you're wild. There is a difference, my friend. I read a whole article about it. Tilapia is good? Oh no. No. Tilapia is, I think it's like all farm raised. I don't even know if there's any nutritional value in it. When I was younger, I used to eat tilapia, but I love eggs. All kinds of eggs. Tilapia and catfish are bottom feeders. Yeah, wild caught's going to have more of a smell. Yo, the cheat to cooking, man. If you don't really cook, buy an air fryer. Especially if you have kids. Oh, it's just so much easier, man. It just takes all the. You don't even have to really keep an eye too much on it. Just throw it in the air fryer. Yeah, omega. Well, that's the thing too. The farmed salmon have way less omega 3s. I think they're fattier. Each pound is more calories. The wild caught has more omega 3, less calories, more like leaner. I've had my mahi. I don't know that I'm a big fan of it. What's your favorite fish? Yellowfin is good. I think I've had like kingfish before too. It's pretty good. Crab legs are amazing. I love red snapper. My stepfather, well, he's not really my stepdad anymore, but he's Jamaican, and he would always make red snapper and peppery, like hot, like spicy. It was really really good. I love red snapper. Red snapper. He would do like fried dumpling. Mm. So good. Tilapia and flounder are genetically engineered. TMI creation. So I believe that. Suggested meal for the air fryer. I think salmon comes out really good in there. I think the burger comes out there. I feel like the burger on the stovetop is a little bit better, but it can still be really good on the air fryer too. You just have to be careful. The thing with the air fryer is you got to be careful if it dries it out, overcook it. Can happen pretty quick. I never tried shark. I wanted to try shark. My uncle was barbecuing shark a couple months back. I couldn't go to the house, so he was at my aunt's. Um, yeah, I think air fryer, beef, chicken. Chicken's really easy in there too. Chicken, beef, burgers. I mean, for the kids, fries. You just throw some fries in there. Fries come out really quick and easy. Comes out crispy. Chicken nuggets. Or reheating food, pizza. Reheating pizza in there. Smoked trout. Grilled bait. I don't know if I've had any of those fried catfish. I heard eel is really good. I've never tried eel. Not a calamari. I'll eat it fried, but like everything fried tastes good, right? I've tried fried alligator, which I feel like fried anything, you're not really getting a real experience. I need to try like actual alligator that's not fried. I'd be down to try it. Oh my god, he tripping, Jay Floyd. How far are we in? 20 minutes? We're about to lose a 30-minute. Well, we got 10 more minutes. I can't imagine. I can't see it going past 1 hour, but I don't know. I'm sticking with 30 minutes to see. I mean, unless there's one person on there that's kind of like, I don't know, maybe they feel a type of way about mental health, or maybe they have a family member, or maybe somebody's been attacked by somebody that has bipolar, so they feel some kind of way. I don't know. Chicken in a can. Oh, that was so disgusting. We pulled it up. I don't know if we have that clip anymore. I don't know if Mo's watching. I think that clip is lost to the game, to the Discord. We had a clip of this disgusting chicken in a can from Amazon. We got that thing anymore? I'd never seen something so disgusting before. Some people say, no, it's good, man. It's really good. Do we have that chicken can clip anymore? I think we were trying to find that last time. Is it really? We played it on one of the streams. Chicken in a can. I wish we could find that. That thing would make me kind of gag. Do we know where it's at? I kind of like Spam. If you cook it, I was never into Spam until we had a hurricane one time, and we had to like ration the cans and shit and we ate some Spam. I mean, it wasn't cooked. I thought it was all right, but if you cook Spam, actually, I kind of like it for breakfast. I never buy it, but I had an ex that'll cook it sometimes. It actually tastes good if you cook it. I like corned beef too, like in the can, like a quick meal. iCkEdMeL, you deleted it. It was in recipes. You guys remind me every time I delete one of the things, huh? I deleted it because I think they took that product. The product was on Amazon. I think they took it down. It was like a nasty thing of chicken that they opened up in the. Hurricane, yeah, Spam, right? Spam is huge in Hawaii. What is Spam? Is it just mixed meat? Like just like leftovers when they chopping up meat and stuff? Chicken Video Discord, you got it? No, that's not the one though. I mean, I guess we'll take it. We'll take what we can get. There was a really, really disgusting one. I wanted to get the goriest can of chicken that we can show the people. Can of chicken. We'll use that one if we have to. Let me try to look one more time. Let's see. Oh, is this one? Let's see. Bum, bum, bum. Ooh. Oh, there we go. This one kind of has the effects. Oh, this is perfect. Look, check this shit out. Perfect. Oh, excellent. Hold on a second. I haven't looked at the one you sent me, Diggs. Let me see.
Today I'm going to.
Oh, this might be kind of what we need too, but I think I found one even more disgusting. The one you sent me looks semi-decent. Somewhat. We'll look at both of them.
Many nice desserts many years ago, but now it's going to be used for holding. Oh my God, it's like somebody drained a drain that's been backed up for many years. And I wish there was another verb I could have used there other than drain, because then I repeated myself. I'm putting off pouring this out. It smells chickeny. Oh yeah. Whole chicken, whole chicken, whole chicken in a can. It's nearly drained. There's some sort of props left over from one of the Alien movies coming out, I think. Yeah, get a load of that. Yeah, that's the stuff. I'm going to have to eat this at some point, aren't I? Oh my God, right. So we've got a bowl full of what I can only assume is some form of congealed fat that's gone a completely fluorescent orange, and something that looks like it's been puked up by something not of this earth. It smells very chickeny, though, it must be said. And now, prepare yourself for a whole chicken in a can. Oh, hang on. The thing's stuck. That's not good. Here we go. Oh, marvellous. Any vegetarians in the house? What's that? All of you now? Do you know, the one on the internet that I saw did actually come out as a whole chicken, so I was kind of expecting that. This, oh my God, who here, I don't know why I'm asking this as a question, put it in the comments, there we are. Who has seen the movie Beastmaster, the 80s action flick, one of my mum's favourites, coincidentally, where the actor Mark Singer is off on a magical quest and team...
I'm not sure why anybody would want this when you can go buy something in the store that looks decent or whatever. I have no idea why people would, or why this is even a thing. Chicken in a can. I'm not sure. This is just... This is something Gordon Ramsay would see in his sleep paralysis. Man. Did he eat? Hold on. Did he eat this stuff? Let me see. Did he cook? Oh no, but did he eat it like that? Oh, you can eat the chicken straight out. You don't have to cook it. It's cooked already.
Bit here that actually looks vaguely cooked.
Ah.
Tastes of horrible meat gelatin, like the stuff you get in cheap pork pies. There's something with a chicken texture that's turning a little bit to dust in my mouth. Not really any flavour of chicken. That's amazing. They've managed to take an actual real chicken and make it not taste of chicken. I mean, that's like some alchemy going on there. That is amazing. Yeah, there's all I can imagine at this moment is Dan sitting at home and saying, thank God he didn't bring me in for this one.
This dude took one for the team. Oh,
chicken bones.
That is so nasty. I wonder how they just put a bunch of salt. Is that how they preserve it? I don't know. I guess it's somewhat cooked and they just salt it up. Oh, I guess if you don't want to cook, you just get a chicken in a can. This other guy, this one looks a little bit more decent. I think we should move on from this after, but let's see.
Let's dump it out. Oh my gosh.
Ugh.
This is definitely well cooked. Little chicken over here falling apart. It's probably been cooked for hours and hours, probably like 12 hours boiled, because it falls apart so easily. That's insane. Wow. Let's do a taste test now.
That's so crazy.
I think you're supposed to do a little bit of cooking with that, but there's a chicken wing. I mean, that's actually pretty good.
The Russians. This is good. This is what better than what we have in the options. We eat this. It's good. I wonder what the expiration date on that is. Yo, so we're creeping up to 30 minutes. Oh. That was crazy Russian hacker. Chicken video Discord. Thank you, Diggs. Ian Thomas, 5 months. Thank you so much for resubscribing, for your content, especially for the mods. Thank you. Rip Van Lugenbill. Thank you for the membership. It's just Christy. Thank you for the membership. Layla Lai. Thank you for the 7-month membership. Mel mods chat. Make it fun. Thank you, Tazzy. Thank you for the 4-month membership. Hit my milestone correct. Miss Deefy, Christy. Thank you for the memberships. What do we do, man? Melissa Hart says it's disgusting. My grandma will put in lettuce, onion, and olive oil and eat it as a salad. What? My grandma will put it in lettuce with the chicken and an onion and olive oil and eat it as a salad. Can you find a victim? Oh, sorry. Can you find a picture of the victim? Yes. Chat Therian. The GoFundMe's in the description as well. It should be. Double check. I don't know if they put a picture of him in the GoFundMe though. Yeah, the GoFundMe's in the description of the video on YouTube. Oh, they did put a picture of him there. It's a little blurry, but it's thundering nasty. I wonder what the talk and conversation is like. I did a jury duty one time. I've mentioned this a couple times. James Layritz, a couple times. Chicken salad. Oh. And we talked. There was one lady that was giving us a hard time, kind of putting up a fight. Kind of like, But at some point, we also were like, you know what? Let's just kind of order dinner and chill. And we were just kind of chilling, kind of laughing. I think we exchanged phone numbers at the time. They used to send me like Christmas cards and stuff like that. We became friends because it was the trial was like a month long. It was a really long trial. New copyright matches found. Let's see what they got. Oh, what is this long crime? Oh, we usually. Okay. What else? Oh. Long Crime did a video called "Jury Forced to Decide." Taylor Schabusiness sanity after convicting her of gruesome murder. Oh, so we just passed 31 minutes. We're at 31 minutes. Um, Ellie Mae, thank you for the 21 months. Wow. Thank you so much for resubscribing. And Princess Chicken, thank you for the 3 months. Thank you, Mel, for everything you do for us. You are the best. Thank you. Damn, bro, it's so nasty outside right now. Nasty. Gypsy, thanks for the super chat. Says, holy shit, you left for like 4 hours and you're still alive. We're at, let me see, we're over 9 hours now. Let's see, we 5.5 earlier. How long have we been here? 4:15, so 9:15. Going up to 9 hours and 30 minutes. Better pick on Discord. Oof, the TikTok one. Lord almighty. Oh, this is the one I think. Sweet Sue. Sweet Sue, say it ain't so, Sweet Sue. Oh, I love my Sweet Sue chicken.
Oh, it's all gelatinous.
Oh. They feed the dogs?
Oh, the noise. Oh.
Get out of there.
You wascally wabbit. Oh, gosh. Oh, you can hear all the gelatin in there.
Wait. Just let it go.
Oh, it's coming. It's crowning.
Prairie dogging.
No, because it ain't going back in.
What's wrong with these people, man? Why do people buy this shit? This should be put on a list. People purchasing this stuff should be put on a watch list.
I will never be the same.
Oh, I should get like a storm cam. That shit would be dope. I could set up a camera or maybe another camera and just get something outside. Storm cam. Can you guys hear the thunder or no? Maybe I can remove the noise reduction. You can hear it. My daughter puts ketchup on corn and cob. Wow. I love ketchup, but not on corn, though. Rosebud, Southwest Florida. Let me see if I find something for us to watch then in the meantime. I don't know. I was hoping that it was going to be... wasn't going to be long. Why did I get like a nice wallet? You know the issue with these wallets that I get? They mess up all my cards. The strip, all the strip of my cards get fucked up. Like, and the security stuff, everything. Like, I mean, I can't. I was trying to use one of my cards the other day. It wouldn't even work. Like, things like this. Like, it's just. I need to get like a wallet that doesn't. Is this leather crap or is it like fake leather or something? What causes that shit with these wallets? It just messes up everything that's inside is damaged. I was gonna get one of those little sleek. What do I need, like a metal thing? I need a titanium wallet or some shit. I want like a metal one. I just want some metal shit. It's not gonna ever stain the shit again. I'm tired of this shit rubbing off on it. Can you get that? A carbon fiber wallet? Under a flash flood warning? You sure? How do you know? There's no flash floods over here. There's legit a carbon fiber wallet. Oh, that looks dope. They sent this to me. I want something you can run over with a card. It holds its place. Switch wallet. All right, let's see what's going on here online. All right, so we're coming up to the 40-minute marker. Oh, where we at? President Biden's dog facing eviction from White House. Oh no.
The Biden's German Shepherd may not be calling the White House home much longer after a number of incidents in which the dog has bitten staffers, including Secret Service agents. Like the Biden's other dog, Commander may be moving on.
Is Commander the first family's dog facing eviction from the White House? The German Shepherd has bitten 6 Secret Service agents and acted aggressively a total of 10 times. One agent was forced to use a chair as a shield.
Wow.
Another was taken to
vicious. What's his name?
To a hospital with bites to his arm and thigh. The New York Post is dubbing the first pet Commander in Chomp.
The White House complex can be unique and very stressful.
Isn't that a security risk? I would have got rid of that dog. That should have been gone. If it was me, you're going to be buying me multiple times. Something wrong with that dog, man. Aren't they under like high training and stuff in the White House to get the best training and best lifestyle?
The first family is working through ways to make this situation better for everyone.
Now some are asking, why hasn't Commander been banished from the White House?
When we see dogs behave in what we consider an aggressive manner, it's them being anxiety ridden. They're being like, what the heck is going on? This is not normal. This is not my world. You're making me nervous. He probably needs a different situation. This is probably not the best situation for him. There's too much interaction. He needs a more controlled environment.
Meanwhile, we're learning more about Hunter Biden's disastrous day in court.
story, a stunning and shocking turn of events in the Hunter Biden saga.
The federal judge rejected his plea deal and told the troubled first son to look for a job.
As the deal unraveled, Hunter Biden appeared increasingly upset.
In court, Hunter revealed details of his battle with addiction, telling the judge he's been to rehab 6 times. He pinpointed the exact day he took his last drink, May 18th, 2019, 2 days after his marriage to wife Melissa Cohen. Some on Fox News.
Last time he drank was 2019? That shit.
Shocking turn of events in the Hunter Biden saga.
The federal judge rejected his plea deal and told the troubled first son to look for a job.
As the deal unraveled, Hunter Biden appeared increasingly upset.
In court, Hunter revealed details of his battle with addiction, telling the judge he's been to rehab 6 times. He pinpointed the exact day he took his last drink, May 18th, 2019, 2 days after his marriage to wife Melissa Cohen. Some on Fox News celebrated the collapse of what they see as a sweetheart deal.
Hunter's sweetheart plea deal on tax and gun charges collapsed into what I thought was a beautiful pile of rubble.
CBS legal analyst Ricky Kleeman says Hunter needs a new deal ASAP.
Hunter Biden cannot afford the possibility that if Donald Trump or another Republican should be elected president in 2024, that they might not come back and prosecute him. So they need to resolve this.
The judge gave Hunter Biden's attorneys and the prosecutor 30 days to work out a new deal.
41 minutes and still going. I'm a little surprised, man. Is somebody putting up a fight? Are they, what are they talking about?
These are.
I wonder if they ate. Are they eating before they make a decision? Uh, 4 reasons why it's important to get vaccinated.
Vaccines are a convenient and preventative health measure. Measles, mumps, and infections, and death. They prevent. Every year, the millions of adults.
I can't believe it, man. I thought we'd be done. Accidental and intentional glue mishaps.
These people had accidental and intentional glue mishaps. In 2022, climate activists glued their hands to sports cars to protest the automobile industry. Members of Extinction Rebellion went to the Paris Motor Show to raise awareness for the use of fossil fuels. While glued to the Ferrari sports cars, they chanted Auto Show of Destruction and Extinction Rebellion. Extinction Rebellion France tweeted that it believes the auto industry seeks to wash its image with green vehicles, but which continues to promote the individual car as the transport of the future. The organization said the automobile sector alone is responsible for 15% of greenhouse gas emissions in France. Extinction Rebellion hopes to.
Wow. So we're at 45 minutes, still no decision. Oh, man. Wow. What in the hell is going on? You guys, somebody chose an hour. Mandy chose 2 hours. Wow. The last Ronin says, doesn't it take almost an hour to fill paperwork out? I don't know. I mean, yesterday was under an hour. It was like 42 minutes. Whoever you're streaming is lagging. The verdict is in. Is it? This is Law and Crime, one of the main people that are inside the courtroom. I'll take a look at Court TV. Why can't we be friends? Why can't we? Just order that wallet for tomorrow. Oh look, there's another channel streaming in as well. I didn't know this channel was another news channel. As far as I see, everybody's waiting. So I don't know where you heard that they got the verdict. Not on YouTube unless they tweeted it out, maybe. Chose 1 hour. There was a thing that I used to follow too called Verdict Watch or something on Law and Crime. Verdict Watch. Yeah, man, we need a break after all this shit. 15-hour stream. Like, what the fuck? Boom, boom. Oh yeah, I should change the title. Verdict Watch, right? Verdict Watch. Rip Van Vlogenbale. Hello, how you doing? Hello. 47 minutes. 47 minutes. They said it is not in yet. Yeah, I don't know where that person got that from. 47. Let's see what else we got. Who's having chicken in a can tonight, Mandy? Thanks for the super chat. Can read supporters gather outside hearing. You know what we should do? Let me take a look at this. Take a look at Reddit. Water Park Karen.
We're good. We're good. It ain't none of your damn business what I allow her to do.
Man, it's just gonna get worse. Probably cover up.
Man, she just say that to everybody else then.
It was a pool. What do you expect her to wear? Cover up on the walkout.
Don't worry about it. Don't worry about it. Go home. Don't worry about it.
Woman's telling her to cover up, telling her she's looking like a hoe and stuff.
Oh shit.
Are you drunk? Who gets drunk at Aquatica?
I got it all on video.
Go home and sober up, lady. You're not to mind your own business. Go home and sober up. She is 16 years old.
Oh my god. No, Karen. Upset about oil change that got canceled at Walmart.
Shut up, motherfucker! You asked my dear for an hour!
Yeah.
You have to get out so you don't need to.
Fuck you, motherfucker! Yeah, why?
You have to get out.
This a useless person! They waste my time!
What happened?
Huh? What happened? His oil I leave a call 10 a.m. in this morning.
His oil change was canceled. I guess nobody ever called him. The oil filter.
Why you not call me?
I don't know why he wasn't called, but.
Why you not call me? If you call me, I'm taking that motherfucker. Why you put like this filter? Everyone talking. What is this? You know the situation. What's going on?
Yeah, I know the situation. You got an oil change your last plate. You gotta go back to last.
Yeah, so you call me.
Yeah,
you can't have a problem. Why they don't call me?
Yeah, exactly.
Why they don't call me? Why they don't shut up, man?
Back up.
Fuck you, motherfucker. Come on, motherfucker. You inside working in a warehouse? Come on.
Can you come to hotel ASF?
You come out. I will show you this. You don't know anything and you come out, you talking.
What happened to it? What was the... I don't know if I can play this music.
Dumbass bitch. What are you gonna do? What you gonna do? Here's my license plate. Here it is. My daddy's a popo, bitch. What you gonna do? My daddy's a popo. Bye. Dumbass bitch. Keep recording me. I'm pretty. Keep recording me. I'm pretty. What are you gonna do? I'm pretty. Get on. Jack off to it tonight. Jack off to me tonight.
Wow.
I already got your license plate. My daddy's gonna come get your ass. Bye.
What the? I should have ordered something. You know what? Since we're stuck here, right? Fuck my life, right? Can I still add to this order? See, I don't know if I can still add. Can I add to it? Okay, there we go. Should we do like a wine or something? I don't drink on stream 10 minutes later drinking. Let's see. I can still add it. I don't know when these groceries are coming, but shit, we're gonna be stuck here all night. I can't, bro. We're almost to an hour. See, this is what happened last time when I snapped. I'm chill. I don't care now, whatever. But like, bruh. No, I refuse. I don't care what you say. No. Please. How many jurors? We all feel this. No, I refuse. No. What's going on in there? Maybe they're eating or they're filling out the paperwork, right? They gotta be filling out the paperwork or some shit, right? Let me see. Did I add it to the order? I added it. Okay, perfect. When is the shit coming now? So is somebody in it by 7:52. Okay, like 20 minutes. It's 21, 22, 32. Oh, 30 minutes. 52. Man, it's just forever. I thought it was be faster than that. Come on. No, I didn't do that. What am I supposed to get? Sponges? What? I thought I had sponges under the sink. Don't drink, man. The road to sobriety.
Wait, say it again. Hey! Get off of me! Get off of me! Get off of me!
Film me.
The lady gangster over there. Lady harassing me for a year finally assaults me.
Wait, say it again. Hey! Get off of me! Get off of me! Get off of me!
Film me. Don't film me. No.
Oh, damn, she fearless too with the dogs.
Get off of me! Get off of me!
Wow.
Get off of me! Get off of me!
I'm not on you. I'm not touching you. And she grabs his ass. Man, look at those teeth too grinning.
Damn, these guys are
Karen's caught stealing laundry detergent.
good. Look at them stealing.
Oh, creamer for the coffee.
Really, bro? You gotta resort to this? Economy's not that bad.
We can't Finish. You never call me. This is the only time you ever call me.
Hold on. Better get it while the getting's good.
My first.
Oh, damn.
TikTok has its own. Yeah. Yeah, I don't know if you can. I think StreamYard. I think you can do TikTok. I think I use Streamlabs. Yeah, I think StreamYard you can do TikTok. Oh, that's okay. I'm just fucking with you. All right, bye. I am live. I'm just giving you a hard time. Okay. It is true though. You only call it this time. All right, bye. I should probably go walk a little bit. Karen was upset. She was feeling more entitled than everybody else and felt she didn't need to wait to leave the parking lot. She just had the right to go against the flow of traffic and in the lot and cut people off until she got out and began our conversation. But not only screaming, but crying. That's real.
You're not gonna get out that way, so you can try all you fucking want. You're acting crazy right now. This guy's trying to get out first. You want to make a fucking big deal with McDonald's? Wait. You guys were last in line. So you want to make a big fucking deal.
Oh, they completed the shopping already. Oh, yeah, that was quick.
Fucking delusional, lady.
Did I get my order?
You're worried about fucking getting out.
Babe.
Oh my God.
They're insane.
Relax.
They're so nice, right?
You're fucking crazy.
He did get it.
Make a big deal.
Babe.
Hit my truck. Hit my truck.
Hey, be careful now.
I'm not gonna fucking listen to you if you're gonna be an asshole. No, you get out first.
Oh.
Where are they from?
Bitch, you're fucking
Alberta.
You're a crazy ass bitch. Enjoy your Happy Meal.
Oh, this was kind of funny. This shit. Or somebody has a compilation.
So let's take a look at this. I'm guessing they didn't pay him or something?
Oh, he's like reacting. That would have been nice. Weird.
It's fun at this point. She's trying to hurt him.
Wow. Nuts. Wow. What a weirdo. She could have put her foot in front of him and kind of kicked him too.
Just like I do, there's nothing you can do about it. No, it's nothing. It's okay.
Woman freaks out over service dog being in a restaurant she's at. Oh, se terminó. Oh, se terminó. Let's go, se terminó. Oh, hey, ya, bangunga. Whatever that means. All right. Verdict reached. We can go to sleep. We can go home. We can go home. Verdict reached. Boom, bam, slam, I go from the beat goes on, na 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 na. Just looking. You guys got what, 1 hour or about an hour? So who wins, the 30 minutes or the hour people? I guess the hour. Closest to the hour. Yeah, look at the judge. All right, we made it. We made it.
Okay. Anything to bring up before the jury comes back, Mr. Saunders? No. Mr. Freilich?
No, trial. It's too late to vote. Don't try to put your votes on that. I see the vote numbers going up.
Okay. Anything to bring up before the jury comes back, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right.
So I think we'll definitely have to come back for sentencing tomorrow. I guess hopefully tomorrow. I don't think it'll be 10 hours. I'm thinking 2 hours maybe. Imagine they deemed her not mentally fit. Way back, way back. I have to order all this stuff on Amazon, the rest of the stuff.
Seated. You are the foreperson, is that correct? Yeah. If you could hand your verdict to the bailiff. Okay, be seated. Okay. You are the foreperson, is that correct? Yeah. If you could hand your verdict to the bailiff. Question 1. At the time the crime...
All right. We made it.
Okay. The verdict seems to be in order, and I will read it as follows. Question 1. At the time the crimes were committed, did the defendant have a mental disease or mental defect? Answer, no. There's no answer then for question 2. It is dated this date, July 27, 2023, signed by the foreperson. There were no dissenting jurors. Is there a request by either
facial
parties
reaction
to have
from
the jury polled? Mr. Saunders?
No.
Mr. Freilich?
Yes.
All right. We did this the last time, ladies and gentlemen. I'm going to poll you again. I'm going to start in the back. Ma'am, are these your verdicts?
Yes.
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 Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Start down here. Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Ladies and gentlemen of the jury, your service in this case is now completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest you treat any discussion with a degree of solemnity, such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or criticism of any person. Please respect the privacy of the views of your fellow jurors. Finally, I'd like to address you before you leave, so if you can just wait in the jury room for a few minutes, I'd appreciate that.
And you may confer with me at any time before answering any questions from anyone. I wanted you to know that as well. And with that, we excuse the jury. All rise for the jury.
That's it. Justice for Dad, Leon, family, and friends.
Be seated.
What?
Then, having received this verdict as well as the prior two, does the state have a motion regarding the verdicts? Mr. Saunders.
I'd ask the court to accept the verdicts and enter a judgment of conviction. I do have a certified copy of a judgment of conviction, case 20 CF 998, as the basis of the repeater allegation in counts 1, 2, and 3 of information.
Those will be received. Mr. Freilich, any response to that request?
Your Honor, I bring a motion for judgment notwithstanding the verdict. I believe there's testimony, ample testimony in the record that my client was suffering from a mental disease or defect at the time of these offenses, and that she lacked the substantial capacity to appreciate the wrongfulness of her conduct and conform her conduct to the requirements of the law. I'd ask that you consider all of the testimony from Dr. Lighton, who is a seasoned veteran in the field of psychology, and the record. Thank you.
Thank you. Well, I've listened to the entirety of the testimony over these last several days, and specifically regarding today's testimony with regard to the responsibility phase. I'm satisfied that the evidence is sufficient to support the jury's verdict, and I'm going to adjudge the defendant guilty on count 1 of first-degree intentional homicide as a repeater, count 2, mutilating a corpse as a repeater, and count 3, third-degree sexual assault as a repeater. I'm going to revoke bond at this time then, and I'm going to order a pre-sentence investigation report be conducted. I'll order that be released no later than 1 week in advance of sentencing, and I'm looking to schedule a sentencing date. September 19th.
Let's check that out here. I already have a scheduled jury trial on September 19th and 20th, Your Honor.
Are they doing sentencing separately, or what is it? Oh. You got like 10, 11-hour days over there, huh? Imagine covering something like this for 6 weeks. 10, 11-hour days.
September 26th.
Sentencing date? Okay, so I guess we won't be here tomorrow then? Or are they going to do the impact? Or the impact happens after sentencing, right? Because like Glory Valley is coming up too, right?
Would it be
mistrial
set for the whole day? For half a day? I've got hearings that day, but I could try to move some things around.
I understand, Mr. Freilich, and I'd appreciate it if you could do that. That's 2 months out. I have things on that day too. And
hell no.
Getting a phone call. You might be getting a phone call from my office asking if one of these cases can be moved, which will be easy to get permission from me to do that. But I would schedule it for 8:30 in the morning. I don't know how long it's going to take, but I would plan on the matter taking the entirety of the day.
Damn, man.
Your Honor, I think I can move everything, but if it could start at 9:30?
Sure, I don't have a problem with that. 9:30 in the morning.
It's iconic.
Mr. Saunders, I see you checking in the back with, I'm assuming with the crime victim. Is that
okay? So we got another
acceptable date
whole
to
day
schedule?
thing.
Yes, I believe it is. Okay. September 26th, 9:30 in the morning. I'll have that scheduled for the balance of the day.
Okay. September 26th. So another 10 hours, I guess. September 26th.
Yes, to start at 9:30.
Yes.
All right. Very good. Anything else before we adjourn, Mr. Saunders?
No.
Mr. Freilich?
Your Honor, that pre-sentence report, if I only have a week, I can imagine this one's going to be long. Could I have a little bit more time, maybe get it 10 days before?
I will. Here's what I'm going to do. I'm going to order that it be released no later than 2 weeks in advance of sentencing. This hearing is about
26?
2 months out. I didn't count the weeks, but I think we can get it done in that amount of time because they tell us they can get them done in 6 to 8 weeks. So that's what I'll order. Okay.
Thank you.
And with that, the
Well,
matter
that's
is
10:30 our time, right?
Thank you very much.
Hey, that's 8:30 our time, isn't it? At 9:30 for them. Oh, it's 10:30 for us, right? 30. Okay, so we'll have to schedule, be ready for a whole day. I guess, for sentencing.
I don't know. Some of these people, I guess they take their time. It's done different in different states. I mean, other trials, different states, they just do it right then and there. Boom. That's how Letitia was. The Lori Vallow thing is coming up, the sentencing. They do it separate dates and stuff. Wow, that's it, huh? Yeah. Well, I guess tomorrow I can sleep in, right? No, iCkEdMeL. Part 3 of the trial. That's it. I don't know. As far as trials go, it was okay. Justice for that family though, shat through. That's great. She didn't have a chance in hell though, that's for sure. Not even in hell. Not even in hell. It was an alright trial. It was short. I guess because it's summer and it's kind of a little harder for me to do the trials right now. I mean, I would do something longer if I had to, but I guess it works out. I don't know when the next thing's coming up. That's it. Had she jumped up and done some crazy shit, it would have been a little bit more, you know. Oh my god! We were expecting her to kind of do some nutty shit, but I guess they had a shock collar or a shock belt around her. No, the victim impact statements will be when the trial happens. The hell is like a big ass pimple? What's going on with me? Oh my god! Don't look. This 4K shit is not good. See all the crevices on my face and pimples and shit. The latest technology. What's next? I have no idea. No idea, man. I know CrimeCon. I'll be going to CrimeCon in September. September 22nd, I think. Or 1st? I don't know. 2nd or 1st. I don't think there'll be any other trial before then that I'll be covering. I mean, we'll keep an eye out and see. They need to investigate that dog in the White House. Somebody need to get that dog out of there. All right, man. Thank you guys so much for hanging out with me, and have a good night. I don't know that I'll be on tomorrow. We'll see. I'm gonna kind of take off, maybe sleep in a little bit, and I don't know. We could do tomorrow. We could do the what is it? We could do Ethan Crumley tomorrow, or the Alyssa woman. I think Alicia or Alyssa. Steeler, thank you. Gilgo trial. When is that? He has a hearing coming up, doesn't he? That would be something really interesting to cover. I love you guys. Bye. Adios. Thank you so much for hanging out with me. Appreciate that. Thank you to Ali Noelani. Thank you for gifting the membership earlier. Ryan Apple Snapple, thank you for the membership. Good night. Bye. Bloop.